Item 1.
My lord, myself, Advocate Sandarani Pani from BC Barampur, my lord. And the case is that the applicant is a retired demonstrator and claim UGC scale-up pay, my lord. Several identical cases already passed order and also implemented as per NHS 6, my lord. And my representation is pending as per NHS 7, my lord.
NHS 6 is not court order.
That is government order. NHS 6 is government order, my lord.
May I, sir?
You consider the representation in the light of 6.
Your Lordship, the claim is of the year 30 years back.
You reject it. I keep all contentions open. Even if they make representation relating to some event that took place when Babur had come here in 1526, you can tell it. Long after you cannot come to court, you can tell that.
Yes, sir.
Petitioner's petition prayer is as that. Yes. First up. Counsel for the petitioner submits that despite representation dated 12/9/2020, where is that? Dated date of your representation?
12/9/2025, my lord.
12/9/2025. The UGC scale of pay has not been implemented so far as the petitioner is concerned, and therefore there is a discriminatory treatment. First, counsel submits that if a direction is given to consider the subject representation, justice would be done. First, next. Learned DGA Mr. Lenka opposes the petition, contending that it's a very old and stale matter, and therefore, there being no explanation offered for the delays, writ court should not interfere. First off, this is difficult to countenance in as much as the same representation could have been disposed of on that ground itself. First off, therefore, delay and latches, the arguable delay and latches, are not a ground for keeping the representation pending eternally. That would run counter to the inner voice of Article 350 of the Constitution of India, as has been expansively interpreted by by various high courts in the country. First, in those circumstances, 8 weeks, all conventions can solicit web copy. Next. Item 2.
Please, Your Lordship. The petitioner is a retired teacher.
Make use of the mic.
The petitioner is a retired school teacher. He retired on 31st December 2002. After 23 years of retirement, 10,000 rupees per month has been deducted from his pension account without any notice.
That is with effect from which date?
That is with effect from that, my Lord, as Annex 3, page 17-18. That is from April 2025.
April 25. No reason, no notice, nothing.
Nothing, my Lord.
Issue emergent notice. Mr. Lenka is requested to accept notice for the obese. District Welfare Officer also?
Yes.
Yes. Office.
My Lord.
Stay of recovery till next date of hearing. First one. The subject application in IA number so and so would be considered in due course.
Item 3.
One sentence here. This interim protection is granted on the submission of counsel for the petitioner that no opportunity of hearing was given before taking the decision to deduct from the terminal, the pensionary benefits. Okay.
Sorry
Yes,
for the interruption, my lord. My lord, this is regarding mentioning of memo. There is just some delay. That's why I'm totally unable to mention before this honorable court to
Delay of?
Coming to court.
coming to court.
No, no problem. Don't worry. You came running to the court like PT Usha.
Sorry,
What you want?
This is my fault, my lord.
No problem. What you want?
My lord, this is regarding WPC. I filed WPC before
What
court.
posting of the matter?
My lord.
Any urgency?
My lord.
What urgency?
My lord, 107 proceeding is continued by the
Day after. Yeah.
much less one.
Yeah. Yeah.
The petitioner is a regular primary school teacher. He has been terminated from service without initiation of proceeding. And
Why terminated? That was in 2022.
yes,
You are in 2025, almost end. What is the explanation for the delay?
the explanation is he was not well. Some mental problem.
Huh?
Some mental problem, psychological problem he had.
Mental problems. But
Similar,
what was he?
the primary school teacher.
But how he will do his job if he has mental problems?
No, after termination.
After termination. And
Similar matters have been notice issued.
Huh?
Similar matters notice have been issued.
Issue notice, like accepts notice for showing. So call upon.
Along with that.
It's not necessary. Not similar.
Yes.
We'll call them along with them and we'll decide individually. Next. Item 4.
Yeah, you lordship.
My lord, petitioner is a registered resource person, my lord, under education guarantee scheme, my lord, and the petitioner was working in a government school, my lord. And after closure of the scheme, my lord, benefit has already been extended to similarly situated person, my lord.
Covered by judgment.
My lord?
Is it covered by the judgment?
Yes, my lord.
Which is that judgment?
My lord, WPC number.
Give that. Let us see. Do you have a copy of that?
No, my lord, I have another judgment, my lord.
The scheme has been abolished.
Abolished. But many other schemes are coming up.
After RT Act came into force, all these schemes have been abolished.
But we have directed in some matters that consider within a period of 8 months, you have to consider wherever possible.
My lord, my last representation under Annexure 9, my lord.
You have to take the
Representation.
petitioner's representation dated 28/6/2025, a copy whereof avails at Annexure 9, seeking engagement in some other scheme after the extent the scheme expired has not been considered. First, counsel for the petitioner submits that in similar matters, a coordinate bench of this court-wide order dated 3/9/2021, rendered in WPC 26757 of 2021 between Praduram Jagat so and so has granted some reprieve, and therefore the same should be extended to his client. First, the operative portion of the order reads as under. Next paragraph. Learned counsel AGA Mr. Lenka opposes the petition contending that
Disengaged from 2007.
the question of re-engagement would not arise once the scheme under which he was engaged itself has come to an end by reflex of time. First off, he also pleads the delay and latch is attributable to the petitioner. First off, be that as it may. First off, all that would not come in the way of a decision being taken on the subject representation in a time-bound way and in accordance with law, consistent with the mandate of Article 350 of the Constitution of India. First off, in the above circumstances, 8 weeks silence. Okay. Item 5.
My lord, password.
Passover, what is this matter?
UGC came, similar case, your lordship has
Issue notice, no?
Yes.
Issue notice.
Here, my lord, representation is not there, but his prayer is that it should be considered in light of the judgment which has been passed by the division.
But if you give a representation, they will take a call. Also.
let him file a fresh representation.
You give a representation, I will permit you
That can be considered basing on our.
in the light of that one.
Yes.
Petition prayer reads as under. Learned counsel appearing for the petitioner in all fairness submits that no representation has been given with the hope that the state would extend the benefit as has been done in the case of others, keeping in view the judgment dated 27/3/2019 of the coordinate bench rendered in WPC 20728 of 2019 that has been affirmed in writ appeal number 627 of 2019, disposed of on 14/12/2022. First one. Next paragraph. Learned AGA Mr. Lenka, on request appearing for the OPs, submits that it has long been settled in the realm of writ jurisprudence that the writ of mandamus cannot be sought for ordinarily without making a demand and suffering the rejection thereof. First one, having so contended, now he very fairly submits that if the petitioner gives an appropriate representation supported by vouching material in support of his contention, the same would meet its fate within a reasonable time as may be prescribed by this court, provided that all contentions are kept open. First, this is appreciated. Next paragraph. In the above circumstances and with the above observations, petition is disposed of. Next. Item 6.
Please, Your Lordship. My Lord, the petitioner prays for the extension of leave benefits, which is covered by Jagdish Singh Babu versus State of Odisha. And in a similar...
Same. It appears to be covered, Lordship. Just look into it.
My Lord.
Yes, good. Got past a plethora of orders in matters like this. Dates and other things have not done.
Not changed.
My Lord, no changes.
The subject matter of this petition, Mr. Churi?
No change is necessary. Only this
Covered matter. Who are the parties? Go to the cost.
Government and Director Higher Education.
The subject matter of this petition is substantially similar to the one in WPC 31724 of 2025 between Shri Ranjan Kumar Mund versus State of Odisha and another, disposed of by this court itself, by the order dated 13/11/2025, wherein the operative portion reads as under this and this one. Okay, flat here.
The operator 1. This is it has been written in operator 2. The direction should be operator 1 in the last person. There's no
opposite party number 1.
1. It is not 2 plus blank.
There are 3. Okay, instead of OP2, make it OP1.
1. For 3 and also last bench.
Last one.
Last page at page number 3. It is open to the answering of number 1 to solicit any information.
That remains intact.
So it is 1.
It is one only.
From commission.
Because yes, you are right.
Representation is made on the commission secretary.
You are right. Yes. Next. Item 7.
May I please, Lordship, I am on VC. I am on VC, my Lord. The petitioner filed this petition with a prayer for release of RHCP, MLCP, which was paid by the Annexure 4 on the basis of Annexure 3, but subsequently it was recovered by the Annexure 5. Thereafter, he has filed a writ petition before this Honorable Court. Honorable Court directed to consider my representation, and the same was rejected by the Annexure 1, my Lord. So, I pray further.
310/20.
RHCP is rejected by the Annexure 1, my Lord. So, I am before your Lordship because legally I am entitled for the RHCP by the Annexure 3, which was the policy made by the government.
Are you from? Do you support? Which place you are from?
My Lord, notice is also required because Annexure 1 is rejected by the OP number 3.
Then is requested to accept notice for the OPs. Next. Item 8.
And the kindly be fixed, my Lord.
Take 2 matters for RSP. They have rejected my case on the ground that the clarification is short for.
Let him take notice. Yes. Same accepts notice.
Item 9.
But relates to TG scale. Similar.
Covered?
Yes.
You have changed the.
Yes, I have
factors
changed
here.
the number.
This will, this will last is fine. Please go down. Next.
Item 10.
May kindly pass over.
My brother, I will assist you. Take out the file. Give over court file. Take that. What is this matter? Is it criminal appeal?
Sir, it WPC, sir.
WPC. WPC is filed under which article of the Constitution? RCPC. Take. Say some words, some few words. I want to hear your pleasant voice today. Come to, brother, come to page 9. Read the prayer. What is that order dated 20 August 2025? Annexure 5. Go to Annexure 5.
Admit the writ petition application issue rule called upon opposite party to file show cause as to why the notice number 8949 dated 28/2025.
Correct. Go to Annexure 5, page 27. Good question. Take notice.
Submission special show cause.
What's your name, brother?
Lordship.
What's your name?
Sir Bishal.
Heard Vishal, who has argued well and made out a case for issuance of emergent notice. First, issue emergent notice.
Lordship.
Earlier DSC requested to accept notice.
The show cause ballot, he has already filed the notice. Show cause has already been filed.
Correct.
That may be.
But take this,
Lordship.
and thereafter we will do something. Youngster is there, no?
Lordship.
1, 2, 3, 4, 5. First off, call the short point is involved. Call this matter week after next. Call. You should come read after reading the papers. How many years of practice you have put in?
Sir, it's my first time, sir.
First time you are appearing.
Yes, sir.
But you are doing very well. You are doing well, better than what I did when I was the maiden. I made maiden appearance in the court.
Much obliged, my lord.
All the best. Okay, next.
Item 11.
The petitioners are the teaching staff of a non-government aided college and are agreed by the publication of final gradation list where their names have not been reflected there.
In the final list, your name is not.
Yes,
but there in the draft.
Tentative list, and our name was there.
Why? What is the reason?
The reason they have assigned at your lordship may kindly turn to page number 32. The second part they have assigned. Yes, your lordship.
Final list.
However, the claim of the teachers working against direct payment posts by virtue of court order in 662 category colleges in a matter of policy decision and are under further legal scrutiny of case laws. Pending decision on such claims.
This scrutiny is continuing.
Madam.
Come to para 2. Para 2, last 2.5 lines.
Pending outcome, pending outcome of all the related cases as well as the decisions of on above claims at Annex B, the final list, gradation list of the readers in the cadre of teachers appointed stroke recruited against direct payment post in non-government aided.
Take notice, Mr. Sen.
Let's
Grateful. Sen accepts notice. All the emergent notice to private. To all respondents.
All respondents. No private respondents.
Great. Next.
Item 12.
The instant writ application petitioners are assailing the advertisement issued by the opposite party number 3, my lord.
Opposite, the advertisement is for which post?
For the post of engagement of Sevak Sevika and tribal language teachers in government of schools under SCST development MNC BW department, my lord.
Why you are aggrieved by that? You can also participate.
My lord, my humble submission before lordship that since the petitioners are serving in the said post in a regular against a regular post and a regular basis, And if they will terminate it without any assigning any reason thereof, they will prejudice, my lord. And to that,
How long you have been working?
I am working since the 2023, my lord.
23.
My lord.
But you are engaged only to facilitate regular appointment. Where is your engagement order?
Engagement orders are annexed with the annexure 2, my lord.
There is a joint there.
And similarly,
Against them. There is a one Yes, the order itself says.
my lord, my lord, I kindly glance. I have before this matter. There is one matter that is WPC number 230003/2012 was taken before this honorable court, and this honorable court issue notice to the respondent for filing their objections.
The very appointment order says this is temporary arrangement so that regular recruitment would be undertaken. The Supreme Court said in a half a dozen matters, when such appointment orders are made, you have no right to seek regularization.
The priority should be given.
No,
to the
that
it is a morship. It can be said as morship petition. If the petitioner will be disengaged.
No, I am not president of India or governor. Only they have overseen jurisdiction. Is it not?
My lord, the parity on the ground of parity, the matter may kindly be taken up.
It is on rights.
Because on the last occasion, your lordship issued notice to the opposite party.
Petitioner is seeking to lay challenge to the advertisement, recruitment advertisement, dated 27 December 2024, a copy whereof avails at Annexure 3. Learned counsel for the petitioner vehemently argues that his clients are already working in the subject boards, and therefore, if the appointment is made, their job would be at stake. First of all, learned ASC opposes the petition, contending that the very appointment order dated 29/9/2023 makes it very clear that the appointment of petitioners is only temporary and that they will continue in the engagement till new teachers are appointed in a regular recruitment process. There is force in this submission. Next, in the above circumstances, petition is disposed of. However, it is open to the petitioner to make an appropriate representation to the jurisdictional authorities to seek relaxation of age limit or such other conditions as may be. No decision in that regard is, no opinion in that regard is expressed by this court. Next.
Item 13.
In item 10, your lordship, there is request for interim stage report. Because your lordship, the caste certificate issues as well miscellaneous certificate rule, lordship, that is in favor of me and still now is ending. There is a provision of appeal and review, lordship. The opposite by instead of resorting, they are also now they are proceeding for another inquiry, lordship. Therefore, I pray for the.
No, they have issued show cause notice.
Yes, my
you reply to that.
You lordship plan they notice. Stay may can be for you.
Why stay? You reply. Actually, I did not want to.
I replied also. In spite of that, they are repeatedly issuing notice to me. I replied. That is in my record, your lordship.
Give that. Serial number 10. Serial number 10. Yes. Go there. Where are your...
Annexure 5 is notice, your lordship. So far reply is Annexure 6, your lordship.
1 second. 5 is the notice. Show cause notice. They have said you file a specific reply to our show cause notice.
Correctly, I have given. So far, correctly, I attach my certificate, your lordship, and also my certificate was confirmed by the civil court. That is on the record, your lordship. That I also filed before that, your lordship. But in spite of that, repeatedly issuing notice to my lordship.
Right now, issue interim order of stay. That's what for till next date of hearing. Let us see.
Item 13 matter of the revised scale.
1-3.
Matter revised scale, similar matter already issued notice.
You give them. Same order.
All the connected matters same.
Same. Yes.
Item 14.
Yes.
Yes. Page 80, Annexure 1. The joining report has been submitted by the petitioner. As he was joining in his duty, joining report has been submitted. Then, page 9, Annexure 2, that as the petitioner has been availed leave for the period of from 10/7/2002 to
10/7/2003.
The said leave report has been submitted at the office of the Inspector of Schools, Dhenkanal Circle, Dhenkana, which is called
Page 25.
District Educational Officer for the time being.
Petition, my lord.
Then,
Authority has communicated, my lord, that
page 21, Annexure 3, that as the petitioner was relieved from the medical,
The full salary is given for the same period.
the petitioner has been submitted the medical certificate at
service
the office of the Inspector of Schools, Dhenkanal Circle, Dhenkana.
16 years
Then-
back, my lord.
After that,
No, sir. Now,
page 23,
come to page 25. Page 25.
25 number page देखो.
Page 25.
well, I praise page 23, Annexure 4, that petition has been filed at the office of the Inspector of Schools, Dhenkanal Circle, Dhenkana, that release the medical leave in favor of the petitioner.
It is given.
Yes, it is submitted. Then, as the Inspector of Schools neglected to release the medical leave, the petition has attended the grave officer at Bhubaneswar. This is the letter of the grave officer who was very highly praised me and told me to meet with the Inspector of Schools, Dhenkana Circle, Dhenkana. But as I met with the Inspector of Schools, Dhenkana Circle, Dhenkana, the Inspector of Schools sent this letter with in a roundabout way. He said that the petitioner claims his salary, but it is not.
Take notice. Take notice.
So,
Let AG is
the
requested.
prayer before the Honorable Court.
Notice. Notice. Yes.
ठाकुर का जाको तुम्हें साथ गुजरा
अच्छा
Item 15. 1, 2, 3.
Item 15.
My lord, the TDC scale of pay, my lord, I am entitled but not given. My lord.
Notice is issued.
Yes.
The same order.
Yes, he did.
So, my lord, is a fresh admission.
Fresh admission. Notice. Both get notice. Both.
Item 16.
16 matter, second of litigation. Normal, when claim has been rejected, similar matter also already.
Similar matters we have treated. Yes.
The other matter also.
Issue notice. DG is requested. DG is requested to accept notice form. Yes. Sorry.
Item 17.
17.
Yeah.
Case relates to untreated regularization, identical matter, your lordship has issued notice.
Issue.
Notice issue.
OUT.
Then.
18 your lordship, your case for regularization, but interlocutory application is there, and your lordship is identical matter has issued notice, and interim protection has also been granted.
Interim protection.
My lord, that is for continuance, for that continuance.
Serial number is 18, your lordship also.
In both the matter, same matter.
No, that is 17 is your lordship. Anti-debtor regularized.
No. 18.
My lord,
There are two matters, na?
Two matters, your lordship. Please, it will application need to be changed. I have everything is changed.
There is also OUT.
Orissa University of Agriculture and Technology.
Issue a complaint from this. Learned is requested to accept notice for 6, 5 and 6.
5 and 6, your lordship.
Emergency.
Others are notice to all.
Who appears for 1 to 4?
Yes, Mr. S.C. Roth. I have also served a copy. Your lordship has indicated in that.
Panel counsel is requested to accept notice for 1 to 4. 1 to 4. First, learned counsel for the petitioner submits that this court has granted reprieve in WPC 28494 of 2025, and therefore, these two cases being similar, the same treatment has to be extended to his claims as well. First, a copy of the said interim order dated 10/10/2025 is placed on record. Next paragraph. In the above circumstances, interim relief, as has been granted to the cognate case, is granted to the petitioners. Yes.
Item 19.
19. RSC matter.
19 is RSCP. Notice is issued.
No, already
disposal.
That also Mahapatra judgment keeping in view.
This sentence you have to complete, na? This.
Item 20.
May I please your lordship?
Yes.
Petitioner is added as clock minors. Challenge the annexure 6.
What is that?
That is annexure my pension paper, the letter of this controller accounts, my pension paper has been returned back to DEO Noapada on the ground the one serial number 1. The pay fixation made on the RSC so and so with grade pay 4200 may be re-examined as the employee is not eligible to get grade pay of 42,000 and para 6 months.
They have sought for certain clarifications at the hands of...
My lord, they have suggested for recovery. The last 6 column. The pension madam.
Question of recovery is taken from item number 1.
My lord, can you that RSCP benefit has been asserted as per the guideline and except 4, my lord.
That clarification is sought for the controller of account at the hands of the who is that district education officer. District education officer has to send his comments. Let him hear you and send the comments.
Similar matter, recovery they directly state recover the material.
Till decision is taken.
Till decision is taken, they will not make any recovery. That direction I give. Now, there is interdepartmental communication. That communication you are challenged. What I suggest is, let the district education officer take a decision. After hearing you, until decision is taken, there shall be no recovery. All right? But petitioner is aggrieved by the letter dated 4/11/2025 sent by the controller of accounts to the district education officer seeking certain clarifications. First, the said letter is reproduced for ease of reference. Next one. Kindly be seated. Learned counsel for the Learned counsel for the petitioner submits that the whole contents of the subject letter are contrary to the facts demonstrable record, and therefore the same is liable to be set at front. First, Mr. Hon'Ble, AG, learned AG appearing for the OP submits that it is only an interdepartmental communication, and Such a communication or correspondence is undertaken in the routine course. 7. After the clarification is furnished by the district education officer, a decision would be taken, and therefore petitioner is not justified in hastening to the court in anxiety. First off, he also assures that the district education officer shall take the decision only after giving an opportunity of hearing to the petitioner. Until that happens, there will be no coercive action. First, this is a happy development taking place in today's court. Next, in the above circumstances and with the above observations, writ petition is dismissed. All keeping open all contexts of the parties. We have copied. Yes, next. Item 21. Yes, sir.
Here, a church is before your lordship. This is a centenary church established by the.
Your voice is not audible. Kindly make use of the mic. How see my voice? How the voice of the judges? It should match.
Commanding, my lord. My lord. Here, the church is before your lordship. A church of, according to that, a election supposed to be held within the committee tenure is 3 years.
What are the restrictions imposed by this collector?
My lord,
sub-collector.
My lord,
Page 63.
Page 63, my lord.
Yes. What are the conditions?
My lord, now it is said, it is the minutes of that joint peace committee meeting, what they recorded.
What is wrong with this hall?
Here, my lord, immediately after the tenure, on 25th May 2025, we convened a meeting for election, as it per our bylaw. That was seriously disturbed by a particular person or group of persons. The election could not be, or the forwarding could not be done. So we immediately intimated the police. We handed over the CCTV of the disruption committed by them inside the church campus and here and there. While that matter was still sub judice, few days after, the entire office bearers, including some believers of the church, they were asked to give bond. As if, well, we do not want to say anything because here it is not possible to be adjudicated. But being responsible office bearers, church, we also given the bond, my lord. My lord, what has really happened? Thereafter, the sub-collector has called this peace meeting. We also welcome this. What we propose, it has been time and again conducted, notified, but postponed. So far as notification is concerned, it is neither informed to us.
What notifications?
My notice, this notice.
Kindly see what they have said.
Yes, we have participated.
Last paragraph. Both the parties were advised to settle their differences amicably for the larger interest of the church. Any partisan, narrow-minded and selfish motives are to be clearly avoided, and it is to be ensured that the church functions smoothly till the new president or executive body is elected.
Yes.
Any violation which would affect peace and tranquility in the locality would also automatically attract provisions under section 7. So both parties would be subsequently restrained from entering the church.
Yes. Here what happens, we do not propose or even throwing more towards any of the, because all of them are esteemed members of the church. what we only presently seek indulgence of this court, we have duly intimated to the learned collector, the SP, regarding at least the Christianity calendar celebration coming up. Because the election could not be done, we have intimated the FIR, that investigation is going on, and we are duty bound to hold the election. Because of some interference, or this is purely between intercedents. Those cannot be spelled out also in the court. What we presently agree, there may be further hindrance or hue and cry by certain persons. We have repeatedly requested, please have law and order situation. Nothing, we don't attribute against the sub-collector. We only making folded hand prayers to the learned collector, learned through email, through personal visit. I have annexed all those things. Our interest is nothing, or we are also attributing against the sub-collector. But what has really been, we have been branded or colored that as if we are the mischief mongers.
Very.
My lord,
Both the sides are at once.
both this. My lord, your lordship, how it is? My lord, I am consciously use this word that we have been branded as such. Page 47 may be seen.
The petition seeks to lay challenge to the sub-collector order dated 7/11/2025, a copy whereof avails at an exact 8. First. Next paragraph. Learned counsel for the petitioner submits that the impugned order has the tendency or tendency to interfere with the smooth going of church administration, and that it is one-sided, and therefore is liable to be voided to ensure fair treatment of his client at the hands of the officials. First, learned AGA Mr. Mohanty opposes the petition, saying that the sub-collector has made the impugned order, keeping in view a host of factors which the writ court cannot undertake deeper examination of. First, next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court is not inclined to grant indulgence in the matter.
One thing, subject to your lordship permission.
Yes.
One thing. Now they have asked the removal of the CCTVs also.
Yes.
That is the only crux matter.
No.
It was only because of that.
Because ladies are there.
No, there is no complaint at all ever from any quarter whatsoever.
Why collector will lie?
Lady and two successful
Because in the month of May, we have given the CCTV footages showing the disruption committed. We have supplied to the London district collector also. We are not hiding anything.
Anyway, the collector.
So, once it will be removed, my lord. Because 22nd, because I have made mention.
Having perused the petition paper.
Lordship, at least collector and SP2 looked into this. We have written communications through email and personal visit.
In the matter, broadly being in agreement with the version of letter, impugned letter, which reads as a next paragraph. The vehement submission of learned counsel for the petitioner that the direction to remove the CCTV may not be sustainable, is bit difficult to countenance. More particularly because of what has been stated in unnumbered paragraph numbers 2 and 3 of the subject letter, wherein certain ladies have expressed apprehensions.
There was no lady in the meeting.
He is saying we cannot examine.
Calm lady believers.
First. Next paragraph. When a matter relates to law and order or potential law and order problem, the writ court cannot run a race of opinions with the executive. First, the writ court has its own limitations, which come in the way of undertaking the evaluation of the factors reflected in the subject letter. First off, in the above circumstances,
At least these two, the SP and collector may be asked to look in because the Christianity calendar celebration will be affected. It is our duty to organize.
is dismissed.
That your lordship may.
First, however, this order shall not come in the way of the jurisdictional police officials and the executive taking decision on the representation said to have been made by the petitioners.
2nd and 7th on 2nd November and 7th November itself.
Dated 2/11 and 7/11/2025. Copies whereof avail at annexures.
Annexure 7, 6 and 7.
6 and 7. Date, just look. In accordance with law.
5 and 7. Sorry, 6 is the inspector, 5 is to the SP, my lord.
Next.
Item 22.
The writ court cannot run a race of opinions.
No, my lord, I'm conscious, my
They
lord.
know what is the nature of people, how people behave. After all, religion. It was Karl Marx who said, religion is opium of masses.
Opium, my lord.
Therefore, we shall have to be very careful when interfering with the decisions of the executive.
Like here, in fact, it was not interference, it was hindrance created. That is what our
There are
intention.
only English words are, it's hindrance and interference. In thesaurus, they are a group of.
Synonym, anonym, if your lordship taken that.
Next.
Item 22.
Please, your lordship, for the petitioner hearing.
The 22, I have petitioner came here, and the construction company who actually raises the constructions, so he has filed the writ. If a copy can be given.
New copy?
Yes, my
Will
lord.
call this matter next week?
My lord, only the some urgency which they should not demolish our boundary wall by taking in collusion with the BMC. They have approved an illegal plan in the year 2023. We are living there, my
I'm
lord.
asking you, are you going to demolish anything there?
Sir, let me clarify one thing. 1 second it will take. So there are a plot of land is there.
You can take couple of seconds.
So one big patch of land was there. We constructed, the builder constructed first phase. We built apartments, second phase. They are the first and second phase association. Now, when the third phase was constructed in 2020, they did not raise any objection. There is a road about 30 feet wide road is there, connecting from the main road to the third phase also, which is on the backside. Now, more than 540 flats have already been constructed. It has been booked, people have taken it, purchased. What they are trying to do, on the road itself, they have raised a barricade. Kind of visualize one thing, Lord. It has already been constructed. It has already finished, the handover possession will be there. Now they have raised a barricade on the road itself, saying it is our boundary wall. So the word used as boundary wall is exactly not correct.
With that, the photograph?
My lord, page 67, your lordship. Just 2 pages I will show you.
The photograph of the boundary.
I am showing the page
67.
6.
Give the photograph.
My lord, the photograph of the demolition is at page 73, which they are trying to demolish by the use of bulldozer and using the hooligans, my lord.
Okay, photographs are words to see the photograph.
If it is a barricade, where is the requirement of using the bulldozer culture?
Yes.
At all?
Concrete boundary wall is being.
Bulldozer, but
Yes.
you give an assurance that you tell your client not to do anything. I will not pass order because you want time to file objections.
Right.
But in the meanwhile, if they do something, then I have to direct restoration of the wall itself.
So correct, sir. I bow down, but
Yeah, you take it as a gentleman's word.
right.
I'll just, to my satisfaction.
Part number 2.
Great court is not for satisfaction of the citizen. So it is impossible to satisfy all people, even to the God. Yes, caller. Next.
I appear for opposite party number 2 BMC minutes.
Apprehension expressed by the counsel for the petitioner is to an extent addressed by learned senior advocate appearing for the caveat. Okay.
Deeply obliged. Your lordship.
I appear for the BMC opposite party number 2. A copy may be served on me also, minutes.
Okay, okay.
I'll
Okay. Next.
Item 23.
Well, directed to Conduct and audit to the appeal party 1 and 2, 3, 1 to 1 within a period of 4 weeks. Petitioner sent the order 22 September 2025 till date not
non-implementation of the order. Where is the order, brother?
My lord, kindly have lunch page 7, my lord. In view of the above circumstances, opposite party 1 to 1 are directed to cause audit
of the school in question and its accomplishment, preferably within an outer limit of 4 weeks. Open to the petitioner to furnish whatever side.
We have not got any instruction in the meantime.
Your voice is not audible.
My lord, it has come before your lordship for the first time. Lordship may give me some time so that I can get instruction. But yes,
issue emergent notice. Shall we issue police notice or
the general notice your lordship notice?
Issue notice. AG, Mr. G, accepts notice for 1 to 3.
Yes.
1 to 3. First one. Complainant's counsel. Complainant's counsel's submission that the mandate of the writ order has not been complied with appears to be true. First, more is not necessary to specify. Okay. This is only foundation for levying the 1 lakh rupees cost that way. Yes.
Item 24. 24.
My permit to withdraw my.
You want to withdraw?
Yes, my lord.
Not happy with this judge?
Liberty may be kindly given.
Petition disposed of as having been withdrawn after granting leave with liberty as sought for. Just like next.
Item 25.
May I to your lordship?
Yeah.
In this case, today I file one miscase for stay and let go after the lunch meal. Just I'm filing.
After lunch?
Lunch meal.
Password.
In the meantime, I'll direct to serve the copy to the BMC Council, Provincial Municipal Council.
You want to serve the copy?
Yes,
Let it be tomorrow because
what happened, my lord? The present petitioner, the president and secretary of the Basti, account of Basti, Chola Singh. But the opposed by the 5, they want to form a Maruti Bihar.
You don't want time now. You want to argue.
Special
notice matters. Nothing along with that it will come. Password.
Item 26.
Item 26, I am appearing through BC, my lords. Now the matter has become infructuous, hence not pressed, my lords.
Petition is disposed of as having become infructuous. First one. Next.
Item 27.
May I please, lords? I may be permitted to withdraw this with liberty to file better application.
Why so many people are unhappy with the court?
Your lordship has asked me to examine the Samaradha Pal case, whether the petition is dismissed or removed. Subsequently, that order has not been received, so that new facts will come.
Welcome. Petitioner has moved a memo dated so and so, which reads as a next part. In view of the above, petition is disposed of.
With
liberty as sought for.
Item 28.
May I please, my lords? Here was the petition challenged the report of the state, the scrutiny level committee, where, my lord, under annexure 4.
SLSC means what? State level?
State level scrutiny committee.
State level?
Scrutiny committee. Yes. Now, my lord, basing on the unanimous allegation, a proceeding was initiated against the petitioner. Fact remains the petitioner belonged to scheduled tribe community. His date of birth is 1970. Thereafter, he got the ST certificate in 88 and he joined in his service in 2001. Now somebody has written against him for which a committee was instituted annexure 4, my lord. Annexure for 2 persons against allegation against 2 persons. Your lordship will find for page 32. 1 and 2. One is Manohar Baji, another is Satya Narayan Bhoi. And the report, my lord, without giving any opportunity, inquiry was conducted behind my back. And now, my lord, they have directed, the state level scrutiny committee has said that your lordship will find from the report what you have stated. They have directed that your lordship have a glance to page 37. Now, my lord, they have said that you initiate a proceeding against the petitioner, one, remove the petitioner from his services, and also whatever the land he has taken in, that should be also take step for your lordship will find.
Who has said this?
The state level scrutiny committee has given suggested. Page 36.
Suppose if the caste or tribe is wrongly claimed.
My lord, wrongly claimed, yes, but on inquiry, my lord, I was granted a caste certificate in year 88.
1988.
88. That I have enforced.
One second. Yeah, when you were given a caste certificate?
My lord, under annexure 4, page 27.
I'm asking the date.
Annexure 1, my lord. 6/8/1988.
This was granted by Tahsildar?
Yes, my lord. With a due inquiry, it has been made available.
Inquiry made?
They have inquired because if I apply for a caste certificate, that will be inquired by the revenue inspector. And thereafter only it can be granted to me. And if they want to cancel it, there is an appeal and other provision are there. And basically, but I belong to scheduled tribe where my evidence are there, and ultimately finding also I have enclosed your lordship. If your lordship want, I can go. And basing on that certificate under annexure 2, in the 2001 I got the appointment. That is under annexure 2. Now, my lord, in the
Monty, you take notice.
Yes.
Will grant interim order because of the apex petition that XYZ cannot make representation.
Well, file response.
File response. Issue emergent notice. Monty is requested to accept notice for 1256.
Yes.
Emergent notice to 7. Stay of coercive action till next date of hearing. Personal. Application in IA number so and so would be considered after objections are filed.
No coercive action, my lord.
Yes, I stay. Item 29.
This case, my lord, I'm not getting the salary since 1/4/2024. They have complied the stay order, Annex 3 of the miss case. Miss case, I have filed 12233. 12233. And the OUAT, they have also accepted the order and revoked the termination order, and Annex 7, they have given the budget. They given the budget for the financial 23-24, 24-23-24 they have given. After filing this petition, they have given 24-25, they have not given. And they have said that the scheme has been closed, and that is the reason they have not given. I have given the document by memo. I have the RTA Act I have obtained, and they said I have given 3125. That document I have filed.
Page number
31. That by virtue of memo I have filed that document.
Memo. Last pay that the arrears of pay have not been given to you.
Not been given. 24-25.
For what period?
Since 1/4/2024.
1/4/24 to
24 till today. Annex 7, if your lordship kindly find, page 18, they have also given the budget. 24-25 they have given that 24-25, 23-24. 23-24 they have already paid. This 584.6.
Who has to make the payment?
Central government, my lord, IMD.
For the OP number 2, my lords. Indian Development Department. We have filed our counter. And my lord, this is a scheme.
What is that?
My lord, it's a person, it is coming under the person scheme, that is forecasting agriculture output using space, agrometeorology, and land-based observation. And it's an independent component of agriculture census and statistics. And IMD has implemented the scheme.
No, why, whether he has worked for during the period, has he worked or not?
Yes. My lords, it was for a temporary, the appointment was for a temporary contractual for a certain periods, my lord. And it has been extended time and again, it has been extended, my lords. So my lords, the IMD is only implementing the scheme, that is a person scheme.
So no, I'm asking you, but has he worked during the period between 1/4/2024 till date? Has he worked or not?
VOT says, my lord, VOT has.
In the scheme, it is.
Huh?
In the scheme,
you are not answering the question.
It was for a certain period, my lord. Thereafter, my lords.
VOT is.
You want to prepare and come back?
So, little bit preparation is.
Call up 4 weeks at the request of and so on.
And may I interrupt?
Let him come preparation. Next.
Item 30,
date fixed, your lords.
After 2 weeks it will come.
Yes, the petitioner filed a and will be giving a copy.
Please give space to others. You cannot stand like a good spectator. Yeah.
Yes, the petitioner has filed a I may be given a copy. I am for the OP number 3, my lord, university. Let him serve a copy.
Please give a copy.
Yes, my lord. Today only my learned senior informed me that he has entered appearance.
No, I remember, sir. The counter is also filed.
And today I am
ready. You file it in the registry. This is not the registry.
Yes, sir.
Yes.
A copy of the counter may be served to us.
Give copy and
yes, sir.
Call after 2 weeks at the request now.
Next. Item 31.
May I please, your lord?
Yes.
Your lordship, this IA is for modification of the nomenclature. Inadvertently, it was cited as WPC in case of CMP.
Instead of what it should be?
CMP, my lord, as pointed out by SR.
CMP.
My lord.
Application seeks proper description. That is CMP 33514.
Yeah, my lord, actually, as this is WPC, that was 33514. Once it becomes CMP, the new number will be assigned.
No, what is that number I have to give now?
My lord, actually only the nomenclature will be changed. Subsequently, registry will allot.
Registry will remember.
Registry to take a call on the prayer mentioned in IA number so and so by assigning CMP number.
CMP number. Deep place.
Next.
Item 32.
My lord, a similar matter your lordship has disposed of. But this matter is done.
Yes, or a copy on you. You have to give a copy to the government.
Yes, my lord.
You should be kind to the government advocates and to the court also.
My lord. And your lordship may kindly see this present case is standing in a better position than that judgment, my lord. Because they are on train. This is a trained graduate, my lord. Your lordship may kindly see read petition page 14. Page 14 of the read petition, qualification of education volunteers.
Any new schemes?
My lord.
New schemes, provided new schemes are there.
Yes.
Otherwise they cannot.
No, your lordship has directed, though they were working and you have written and you have pick and choose method.
The copy.
You copy.
Yes, yes.
Because the scheme has been abolished after the Act came into force.
Mr. Lenka.
Your lordship
has already been argued.
Your lordship may call it tomorrow or day after tomorrow. I will verify.
Yeah.
Yeah.
At the request of.
Item 33.
My lord.
Petitioner is a registered small scale industry, my lord. Hearing registration number also at Annex 1.
Make use of the mic. Mic should be made use of.
My lord. Petitioner is a registered small scale industry having its at Jaipur under Tahsil Jaipur, my lord. He was allotted a piece of land. I already deposited that land, that amount. That has not been handed over, my lord.
Land is not handed over.
Handed over.
Despite allotment.
Yes, my lord.
Allotment has been done.
My lord.
When the allotment is done?
Annex 3, my lord.
I am asking the date. Please understand English. Why people are not understanding my simple
16/9/2011. 16/9/2011.
2011. Which annexer?
Annexer 3.
Page number?
Page number 14.
Which unit is yours?
My lord.
Which unit? In the said annexer 3, several units are there.
My lord.
Your unit.
That is at page, my lord. Annexer 2, page 13, my lord. Schedule of property.
No, that should be found in annexer 3, na?
My lord.
Where is that?
Annexer 3, that is running page 14.
That is all right. But where is your property mentioned?
Property mentioned in Annexer 2.
Page number?
13.
It is kindly consider the proposal for lease.
My lord.
It is a proposal.
That was already approved, my lord.
Where is that?
By the that is Annexer 2, page 13.
Annexer 2, page 13, I am saying, where is the approval? Approval is there? You are Sri Sai or Messrs Engineering?
Messrs Santoshi Computers.
Where is that? Where is that? Santoshi Computers?
Santoshi Computers, my lord.
0.4 0.04 acre.
My lord.
You appear for the OP.
Your Lordship, I am appearing for IDCO.
IDCO.
That is the answering OP.
Your Lordship, may see the annexure D/7 of the counter filed by IDCO.
Have you received money from him? Have you allotted this piece of land?
Yes, Your Lordship.
1 second.
That is, my lord, an annexer.
He has deposited all his processing fees and all. Thereafter, which I am referring to annexure D/7, we got a letter from the Tahsildar. He stated that the land has been previously earmarked for the tourism project.
That is, I have already.
Thereafter, Tahsildar also suggested an alternate land.
Did you get give him the alternate land? You have retained that money and pocketed it. How much money you have received from him?
59,000.
59.
When it was? When did you pay that?
My lord, that is 22/5/2018.
Thereafter,
Annexure 11, page 28.
Your Lordship, in annexure F/7, we have also asked the Tahsildar to suggest the alternate land, and IDFO will only approve it only after the sanction of the lease or advance possession, Your Lordship. That is the.
But all through you have retained his money. Since 2018.
2018.
Which is the Tahsildar? Which Tahsildar?
Government.
Yes, sir, Mr. Lanka. That is the reason why the state is not flourishing. He wants to establish industry. He has made the payment as prescribed way back in May 2018. And Tahsildar sends a letter, no, this land is earmarked for tourism department. They send a letter saying that so that some other land. Tahsildar very happily sleeps over the same.
My kindly have glanced at page 15, my lord. That Tahsildar also.
What he said?
Mentioned that the Tahsildar informed that on this matter, page 15. Fifth line, Tahsildar informed on this matter to the house that he has received the above proposal and due to absence of the case record of the concerned land has not yet been able to finalize the is located adjacent to highway and is now in primary location of the Jaipur municipality. The land was earlier under the possession of Indian Oil Corporation and after withdrawal of the oil depot, the land is now free from any encumbrance. That is their annexure 3, my lord. Now in annexure 12 says that is under tourism department.
No, he says it is adjoining the main road in a developed locality. Therefore, it cannot be. How can that be a ground? When he had applied way back in 2018, it was not like that. People, Tahsildar present before the court. We will do something to him.
You actually call it this week. I'll get the instruction.
Call this matter on in the first week of January 20, second week of January 2026. First up, the Tahsildar. Who is OP number?
OP number. Tahsildar. OP number 5.
OP number 5 is directed to be personally present with the entire file after reading its pages so that he can answer the questions that may be posed to him by the court on the next date of the first term. However, the presence will not be required if he does his job by doing the needful. In the meanwhile, okay. Suggest me to share a carbon copy of this order. With
copy also?
Yes.
The copy of
the DDG, plain copy. Yes. Okay. Item 34. Yes.
Here I was taken adjournment to obtain instruction with regard to the letter which the state has come up with the allotment of the land. That they have quantified the premium to be paid for rupees 1 crore some odd 21 lakhs. Your Lordship, to that effect, I want to draw your Lordship's kind notice. Thereafter, your Lordship may take.
What is the prayer? I do not remember. What is the prayer?
Petitioner is the ex-retired naval person.
Ex-naval person.
Retired.
Yeah, they said that they are allotting the land with particular price.
Yes.
Yes.
My Lord, my respectful submission is that they have come up with the letter with regard to the allotment saying that plot number 149 is now allotted to my favor. But this is a false submission because this plot was allotted long back in 1997. To me, my representation discloses that.
The very same plot.
Yes.
Is it true?
And they were saying when I required the information under the RTI with regard to the stage of my allotment and the subsequent premium letter directing acceptance of premium, it was informed to me that since the record is old of 20 years, it is not traceable. So now they have come up with that drawing of that annexure 5, your Lordship can have a glance. Just for a moment.
My lords, this was allotted.
It was allotted to him earlier.
Earlier, he didn't take that land at that point of time.
Letter did not reach him.
Anyhow, as per my lord's order, we have already allotted
the price.
My lord's present price.
No. As in the date you
My lord,
the allotment.
my lord, he has not parted with the money, my lords. At that point of time also.
How much money it was? What was the amount you had to say, fix it for that?
And in their counter, they are saying that it was never allotted.
My lords.
No, kindly answer the question.
My lord.
When was it allotted? It was allotted on what date?
89. Yes, 23/3/1989. There was a lottery and it was allotted.
23/3/1989 allotment.
My lord.
What was the price? Allotment price. What was the price?
Then since no communication was there, then I could not make deposit of the premium.
I'm asking a question.
Well,
Understanding.
I'm sorry.
What was the price?
That time I don't have a right now. I don't have.
According to you, what was the price?
My lord, sir, it is not stated in the.
When you made allotment,
My lord.
price will be stated. He is an ex-defense personnel, soldier, who has fought for the at the frontiers of
My lord, that is why, my lords, after so many years passed the order.
No, that is no justification at all. If you are, because I was given the impression by Mr. G that it was not allotted. That is the stand which you have taken in your counter also.
Lords, there was a lottery draw.
There was a lottery draw on 23/3/1989.
89.
And you had allotted.
Yes.
And as on that day, what was the price? Did you send intimation to him telling, make the payment and take the land? How intimation was sent? By postman or on the horseback or by the parrot?
It was published in paper. My lord.
How he will know?
Newspaper.
How he will know? He is in the frontiers of the country.
After.
Where is the notice? How will you expect that everybody will read newspaper? Even I do not read all newspapers. How will you expect a common citizen, a soldier, that he should read every newspaper? That question arises where you send a notice to him and it is not, despite effort, it is not served on him, then you will make it a publication in the newspapers.
My lord, he retired in 1981.
Correct. 1981, he applied for that.
89, it is 19.
How, when did you send him? You have to make this payment if you want this piece of land. When it was sent, how it was sent. Now, because of market factors, prices have gone up. How can you demand that price on that ground?
No, my lords, as on today, the market price will be 5 crores.
About 10 crores.
My lord.
Assume that way.
My,
When did you demand the payment? When you made the allotment?
my lords, in allotment, normally the condition is there. It is,
When did you send the demand notice to him? Allotment was admittedly made on 23/3/1989, although you had taken a specific contention that no allotment was made.
my lords, in our counter, it is specifically stated that.
What they have stated in that counter?
Page 9 of the counter, annexes C by 3. Annexes C by 3.
My lords, para 4.
Conciliation was taken up followed by detailed discussion with the parties, perused the written note of the OP and found that the OP states to have verified the lease register, and from that it is found that the applicant has not been
with any such plot.
My lords, para 4 I am placing.
Your letter. You are reading the counter. Your letter. Letter of your client. Can you take up a plea in your pleadings contrary to the letter. This is by Secretary DLSA, Kurda.
This matter was referred to.
You have said that it was not allotted. When it was allotted?
My lords, this is by the Legal Service Authority, my lords.
Correct.
My lords, she is no concern.
The written statement.
Unless your department says, why he will enter this, make this entry in the order?
The name is indicated. Who
My lords, that is a legal and application.
Land officer. Additional land officer, namely Sri Nabakishore Tarai, appeared and filed his written statement. And in that statement, he discloses that land was never allotted to me. And on page 18 of my petition shows that I submitted a representation. They have acknowledged it in 2000. I requested for issuance of premium payment order so that I can make payment of the premium. That was long back into the year 2000, I-4-2000. That was received by the diary section of the section 6-4-2000, page 18 of my petition. So what I pray, my lord, if your lordship direct the produce the record showing regarding that allotment of that land which pursuant to that, everything will be disclosed. What they are concealing, what I am concealing.
Mr. Behura,
My lords,
produce the original file.
my lords, provided it is available, my 30 years back, more than 30, 89 means it is almost 35 years back.
Or you reduce the price reasonably.
My lords, I will take instruction because it is always in the prevailing rate. This is not the market rate. This is a rate.
Registration value.
My lord, not registered. There is a notification by the GA department on what amount the lease will be granted to the people. That is, on that basis, it has been done.
Otherwise, what will be the price of this land?
This is the premium to be paid.
Same market value.
Market value is different, my lord. That is benchmark by the revenue.
No, what may be the market value?
Market value, I will take instruction. This commercial come residential land.
No.
Very highly.
But 1989, it was not like that.
My lords, 89, 500 rupees was also very precious. Now,
that's true. I agree. But
my lords, in so far land value is concerned, if it is rising in Bhubaneswar, it is rising like anything.
No, it is raising. Even if government sleeps, it raises because people work. For raising of the price, government has nothing to do.
Nothing to do. It is market value.
There is one famous book, India grows during night. Because politicians sleep. When they sleep, India grows. Theme of the book. Anyway, I am not on that. Now, you produce the file, original file.
My lord,
the director to keep the original file relating to the allotment of this site and other similar sites during the contemporaneous period, for the perusal of this court. Since issue as to then price and present price of the land is cropped up in the course of hearing. Okay. Mr. You also, some miles you have to walk. Now, whatever has happened. Okay? You tell your client to walk a few miles. Otherwise, gap will not be.
Whatever with me, him, I will also produce.
You tell him.
Yes.
Anyway, he is getting a very huge land, worth crores now. That he can make use of.
That is right.
I'll call this matter in the first week of January 2026. Okay.
Item 35.
People also fix a particular date so that I can ask that person also to remain present. If necessary, some query, he can give.
6th of 7th of January.
I'm grateful.
2026. Okay.
Item 35.
My lord, I am from number 1 and 2. My senior last out of station today because last night his brother's daughter was married, but today he was coming here because of the level compulsions. So next week,
Next week we'll have.
Yes, because all the previous occasions, my lord, it is only because of his personal difficulty.
Call next week. Get the request now. Fine. Finally.
No further adjournment.
Finally. Fine. I'll reward.
Similar to item 36, on 18th November, your lordship had granted time to file counter as a last chance, but I see.
And here is a simple.
Little more time, Mr. 2 weeks.
Not completed in sentence.
2 weeks time.
But it was given finally to you.
My lord, we'll see the file counter with the
only
2 weeks.
Small issue has to be decided, my lord, here in this case. Well, last time, my lord, here is one thing. I was
letting file count.
My lord, I have filed in the year 2024. As of date, they are slipping tight to the matter, not filing in
2018-19 matters also. But finally, we'll give time.
My lord.
Finally. Otherwise, we take the petition on
I'll say that it is right.
Question of payment of increment.
2 weeks for filing counter, if any, is granted finally, failing which petition amendments may be taken up with their face value. Yes.
Only one date.
2 weeks it will come. No date will be fixed. I do not know if I am sitting for the same bench. Yes.
Item 37.
Item 37, my lord.
Yeah.
On behalf of Mr. Maharana, on behalf of Mr. Maharana, my lord, we are appealing for on behalf of all the opposite parties. 2 weeks time given for filing of counter. We have already sent this for vetting. We have already sent for vetting. Let it.
You have sent it for vetting
to the ministry.
The same one. Put the request one. Yes.
Item 38.
Item 38, my power is not there. I'm appearing along with Mr. Punaik.
No issue. I treat you as the senior counsel.
No, I'm not a senior counsel.
Yeah.
My lords, this case will file counter today or tomorrow, my lords. It is ready.
Counter to be filed within 10 days. Failing which service. Yes.
And it's a case of termination.
Let us see. Next.
Item 39.
And the order passed by the opposite party number 2, director, is under challenge. Director to file counter in this manner.
Same order.
Counter already filed.
It is filed by the private opposite party, but so far as the director state is concerned, the state has not filed the counter.
My lords, we have received.
Why? How can you expect that it should?
My lords, the instruction we have received, my lords. We filed counter 2-3 days time maybe.
My lord, my post has been approved. By virtue of an interim of this honorable court, I am debarred to getting my salary.
Let him.
But a date being fixed, my lord. But I am not getting my salary.
Salary is also not paid for you.
No, my post is by virtue of an interim, I am not getting my salary.
Stay out of this court or not?
There is a stay order.
Yes.
second week of December.
That's why interim order to continue.
Interim order.
Great.
Till then. Yes.
Item 14 will be taken at 2 p.m. Item 41.
51.
मैंने पहले पास ओवर में
41.
Item 42.
Matter I appeared for opposite party number 6 because we were to fight a counter activity. We have not highlighted inquiry
Within 3 weeks. Same one. 14th, second week of January. Next.
Item 43.
Opposite party member. That's the opposite party. It is. Interim order is there.
Was there?
No, I
Not there. Calling the second week of January 26 to enable function for the petitioner to come and argue. Next.
Item 44.
Same order.
Item 45.
Yes. May I please?
Yes.
The matter relates to re-employment. The matter relates to re-employment of a retired teacher.
Re-employment of the retired teacher.
A retired teacher.
Yeah.
Because, my lord, the school in question is a upper primary school having 2 teachers, one headmaster and one assistant teacher, one science teacher. So far as assistant teacher in science is concerned, he retired from service on 28/2/2025. It's an aided educational institution.
Yeah, retired 28th February.
Yes.
What is the issue in what?
But the issue is, although there is a selection board rules meant for aided educational institutions, no selection board, since selection board is not functioning, so therefore no selection board candidate was sent to that school. So only one headmaster is there, no other assistant teacher.
No, 2 more teachers.
No, including myself, including the assistant teacher Umesh Chandra Das, who retired from service on 28/2/2025, 2 teachers, one headmaster and one assistant teacher. And one teacher has already retired from service on 28/2/2025. Only headmaster is left. Therefore, there is necessity of an assistant teacher, who is a science teacher, for that school. The appointment of that teacher was also approved and he was receiving grantinate from the state government.
He was appointed the post-retirement.
No, but the managing committee made a requisition or recommended his case for re-employment for a period of 2 years in accordance with Rule 19 of the 1974 rules. There is a provision for re-employment because re-employment can only be made with the sanction of the director.
What about the young people? Well, all retired people have to be engaged. But what should happen to the youngsters?
No, my lord, I am not standing on their way. My submission before your lordships is, since no recruitment is met and selection board is not functioning, even if the selection board rules is there, for the interest of the school, a teacher is to be sent to that school.
That will see. And who should make the appointment?
Well, the appointment can only be made as per Rule 19 of the 74 rules.
By the management.
By the management, yes, with the sanction of the director.
Well,
he did not
make the appointment.
Well, appointment. Well, now the director has rejected the same.
Appointment proposal is rejected.
Rejected on the ground that prior approval of the director was not taken. That is first ground. And second ground is that there is no policy of the state government for re-employment.
Correct.
Third ground is they have referred to a government circular which is applicable to the government employees. Your Lordship may.
No, why your management did not take prior permission?
Management has sought for permission, that has been rejected.
Permission to
re-employ him.
No. Permission to make regular appointment.
Regular appointment is not doing. The regular appointment they are not doing.
Who should do it?
Well, the selection board.
Which selection board?
Well, there is a circle selection board.
By the government.
By the government.
Which is the rule which provides?
Your Lordship may kindly see the circle selection board rules.
It's a private school.
No, it's an aided school.
Private aided school.
Private aided school. Aided school.
It's a block grant school.
Block grant school, there is no distinction between block grant school and there is a decision. But this is the rules. The Orissa Selection Board Education Circle Recruitment Rules 1994. But this rules is still in cold storage. My Lord may kindly come to Rule 6, reporting of vacancies. The secretary.
Let us see the definition.
My Lord.
Definition clause. Board.
Yes.
Means selection board constituted under subsection 2 of section 10.
Yes.
District inspector, education district, government, form, inspector, high school, upper primary school.
Ours is upper primary school.
Aided high school or upper primary school.
Upper primary school.
Schedule here. Constitution of the selection board.
Constitution of the selection board.
The selection board for each education circle shall specify in the notification the names of members of the board. The government in the notification has referred to names of president and secretary of the board. Office of selection board. Politics office the selection. Reporting the secretary of managing committee of a unit of it. When your managing committee reported the vacancy?
Well, it reported the vacancies. Well, the retirement took place 28/2/2025.
When the vacancy was reported to the.
Well, immediately thereafter.
Where is that?
Well, that is I have given, and that has been rejected for re-employment.
No, reporting vacancy is
yes.
Seeking appointment of a retired employee is another
thing.
When did you report?
Well,
this is there any format for that?
No, there is no format. There is no format that simply reporting of vacancies will be made in form number 1. Yes, there is a format.
There is a
form
format.
number 1.
When who appears for the institution?
Well, institution has filed this writ petition.
Yes. Then when did you inform, when did you fill the form to the government? I will take action against the institution.
Well, so far as selection board is concerned, well, my instruction is subject to your Lordship's acceptance and subject to verification, subject to the others. My Lord, the queries made by my learned friend. The selection board is not at all functioning.
Don't worry about it. Your filing the form, that vacancy has arisen, is to be given to whom?
Well,
come to rule.
Yes.
Rule 6.
Rule 6. Yes, I am showing Rule 6. The secretary of the managing committee of an aided or recognized private high school.
You have to send
or upper primary school, sir, furnish a requisition by the 1st August of every year to the concerned inspector or district inspector as the case may be. In form number 1 for allotment of teachers selected by the board against the vacancies existing in the institution according to the norms prescribed by the government from time to time in accordance with subsection 1 of section 7B of the Act.
When did you do that?
Well, so far as immediately thereafter, immediately after retirement.
Question is, did you inform the vacancy? Please answer. If all retired people are appointed,
no, my lord, I am not
what happened to the young people?
No, my lord, I am not in that.
All they are on street. They will become pickpocketers.
My lord, I am concerned with the running of the school. Kindly visualize my predicament.
No,
I am concerned with running of the school.
Running according to law.
According to law.
Those industries which do not run according to law should vanish. This is what the Apex Court said.
But since the selection board is not at all functioning,
selection board will be constituted if everybody informs these are the vacancies, therefore make
Well, the selection board rules has come into force since 1994.
Correct.
Since 94, not a single candidate has been selected.
No, yes.
But your Lordship may kindly see. And therefore there is a provision, transitory provision.
Provided I go to that provision if you comply with this requirement.
But
Without complying with this requirement, making backdoor entry of all retired people, leaving all the youths to commit suicide, that I don't agree.
Well, that is not my intention. I will file additional affidavit to that
That is
effect.
not your intention.
No.
Gathers that intention.
No. Well, I will file an additional affidavit when it was reported. When it was reported, I will file.
No question.
I will file an additional affidavit.
Not necessary. This is a fit case for dismissal with costs because you have not reported the vacancy.
But I have
Government will show that.
But your Lordship may give me some time. I will file affidavit.
When do you want?
Well, your Lordship may grant me 2 weeks. I will file.
Matter was heard for some time. First of all, when asked, counsel for the petitioner school institution submits that he would verify and come back.
Yes.
As to whether the vacancy that arose on 28/2/2025 because of eventual retirement of a science teacher,
yes,
has been reported to the inspector in the prescribed form in terms of Rule 6 of Orissa Selection Board, Education Circle brackets, Recruitment Rules 1994. First off, this court doubts in the absence of such reporting whether the institution should be permitted to knock at the hands of writ court. First, call this matter after 2 weeks for further hearing before this court.
Yes.
Otherwise, all youngsters, what they should do?
Your Lordship also
will get everything.
Your Lordship may also direct the State Council to take instruction whether selection board is functioning or not.
That question arises after bunch of vacancies are allotted.
Well, your Lordship may kindly see, previously there was an order by this honorable court that you fill up the post. Fill up the post, but they are not doing it. So far as block grade schools are concerned, your Lordship may kindly see the order dated 25/6/2025. But I am not concerned with any teacher. If they sent a teacher, we will be satisfied. Your Lordship may kindly see.
Why selection board is not constituted?
It is my submission that government is very careful for this, my lord. And in the absence of teachers, my lord, we shall merge the school in the nearby school. Merge the students.
But it's an old school. It's an old school.
My lord, it's a block grant school. We shall give them better in a government school nearby.
Well, it is a solution.
Yes, that is the solution because we are not, my lord,
where it provides for. See, then these schools will commit suicide.
My lord, Lordship, kindly bear with me. Because, my lord, in none of the government block grant schools, we have not filled up the vacancies, my lord.
That is wrong.
Yes. Because, my lord, thereafter, my lord, it is there in the year rules also.
So
I'll provide that.
It cannot be.
Yes.
It cannot be.
I'll provide. This is a precondition probably in the 2004.
Mr. G, your object is not to somehow take away the private schools. Private schools, running private schools is held to be a business by the apex court under 19(1) FRG, G, in Mahe, in the Manipam Institute of Higher Education versus so and so. They said it is a kind of business.
Business that
covered under 19(1)G. You cannot just merge them. Question is, there are rules. You should make appointment to the vacancy, provided they report the vacancy.
Yes.
I'll come up, my lord, with a concrete instruction.
Board is not constituted.
No, my lord, I come up with the instruction, my lord.
Lordship may indicate that.
Mr. G, on being asked as to why the selection board has not been constituted as provided under Rule
That is
Rule 6.
Orissa Selection Board Education Circle Recruitment Rules 1994.
Not 6. 6 is reporting vacancy.
No, Orissa Selection Board Education
that's all.
Circle.
Rule.
That is reporting of vacancies 8 is.
Rule 8.
No, that is
Rule 10.
Rule 10.
Rule 10.
Rule 10. What you Constituent Rule 10 all these days. Come on. Mr. G seeks a short accommodation to come out with the response. First one. We'll call this matter on
Yes, sir.
which date we have fixed? 2 weeks will not be. Instead of that, we'll have this matter next week. Next one. Come out with this.
For a moment, your Lordship, may kindly see the impugned order, Annexure 6.
Yes.
Well, what they say, last but one paragraph, that it has been decided, my Lord got it?
Yes.
That it has been decided to de-recognize those institutions where the teachers have already retired from services and to upgrade nearby government. This is their policy, they say.
Come up with the granted orders, etc., everything.
But when rules are there, these are the private institutions.
You can withdraw the grant.
Yes.
How can you say that close the school? That will be too much. Anyway, let us. Okay. All youths are no concern for the government.
Yes, my lord.
Why you are not? You are already there are rules.
My lord, Lordship, may kindly. Your Lordship have directed me to get instruction. How many posts are lying vacant in government, added, etc.
73,000.
No, 73,000, my lord. There are some promotional vacancies are there where litigations are continuing. I'm getting all. I will get from in this week. I will get the instructions, my lord. I'll come up.
Your Lordship may also ask my learned friend to comply the order dated 25/6/2025. Your Lordship may kindly.
What does it say?
It says that why you have not posted a regular teacher.
Let us.
We cannot provide.
25/6/2025.
School have regular teacher. How can we give?
No, they have answered in the impugned order that we will not provide it.
Yes.
We will work them. That is the answer. This order.
How can we give
not
regular
taken
teacher in a
it is answered already.
Rules.
My lord,
These
how
are
can we
graduate schools.
How can we give a posting to a regular teacher?
But he is admitting that we will not give any posting.
That is
then how the school will run?
The order. That is the order.
But therefore, for the interest of the school ballot, I have come up.
Item 46.
Item 44.
I will permit you to take a regular the temporary appointment of some other person, not the required.
Yes, your Lordship may say.
In the interest of the community of students, the institution is permitted to engage.
Yes.
The services of
science teacher
who has not attained the age of retirement.
Yes, by making
not a retired employee.
By making fresh recruitment.
But by making
it is the business of the management, it is not ours.
Anyway, we have said that.
Yes.
Sorry, item 44 I could not appear. That's why lots of urgent to January. Yes, sorry. What early date make I 6 minutes this year.
They have objections.
92 marks they have filed counter. They have
filed counter. This.
They have filed counter.
Third week of December. Okay.
Item 46 on behalf of Mr. Shah, kindly a week time because of some personal problem.
Second week of January 20. Okay.
Item number 4 in this case.
Yes.
Item 46, my appearance will be noted for OP number 4.
Item 47.
47, my lord, that batch of transfer matters start at the instance of the MLA and MP.
Yes. Start.
Yes. Yes. My lord, your lordship may kindly take up repetition. My repetition, that is WPC number 23834 of 2025.
Yeah.
Ticket. The batch rates.
23834 of 2020.
25.
Okay. Where are the policy guidelines of transfer?
Yes. Policy guidelines.
Can you supply a copy of the guidelines?
I have annexed. I have annexed.
No, apart from annexed, independent copies, if you have one.
Independent. Well, the policy decision is, that is 14/5/2025.
It's in
2025. So far as the power vested with the MLA and MP, that is the government order dated 13/5/2025.
You said 15/5/25. What is it?
14/5/2025 is their policy.
Policy. Means what? Order.
Notification that is under the RTA Act. That is a statutory policy.
Under RTA Act.
RTA Act.
Section?
That is Section 19 and 25 of the Schedule 1 and B of Norms and Standards for a School of Right of Children to Free and Compulsory Education Act 2009 and the Right of Children to Free and Compulsory Education Rules 2010.
Yes. They have RTA Act and RTA rules. What literature you have?
No, that policy.
That policy 14/5/2025. I am placing that policy first.
Let us read.
Yes. Subject: guidelines for inter-district transfer and mutual transfer, intra-district transfer, rationalization of headmasters, assistant teachers, assistant teachers ex-cadre, junior teachers schematic, and Ganashikhaks of government elementary schools in the state. In order to comply with the provisions reflected in Section 19 and 25, and Schedule 1 and B of Norms and Standards for a School of the Right of Children to Free and Compulsory Education Act 2009.
1 second. Whether in all these schools,
yes,
this act is applicable?
Yes.
Where you will be taking the quota?
Primary, upper primary, yes, it is applicable.
They are all government schools.
These are all government schools.
These are all government schools.
Government schools.
So we are all government teachers.
Yes. And the Right of Children to Free and Compulsory Education Rules 2010. Even Compulsory Education Act also applies to private schools also.
That's what I say.
Yes. Yes. School-wise PTR of 30
means
pupil teachers ratio. 30 is to 1 at the primary level and 35 is to 1 at the upper primary level, with a minimum of 2 teachers per school. Rationalization of teachers is essentially required.
What is meant by rationalization?
Rationalization, that is as per the pupil teachers ratio.
That has to be maintained.
That has to be maintained. All elementary headmasters and teachers belong to district cadre and hence they cannot be transferred to another district. Representations have been received regularly from different level.
1 second. All elementary headmasters and teachers belong to district cadre.
They cannot
be transferred. They can be transferred
beyond
in the district.
Beyond district. Inter-district transfer will not be applicable.
Within the district. Revenue district.
Within the revenue district.
2 types of districts are there. One is education district. Other one is
revenue district.
Okay.
There are 2
They
types
do not
of
coincide with each other.
No. The one cadre it constitutes.
Okay.
within district.
Okay. Within district, they are not transferable at all.
Within district, they are transferable.
Yeah. From one district to
Another district, they are not transferable.
That is intra-district transfer.
And inter-district transfer. There are 2 types of transfer, inter-district transfer and intra-district transfer.
Okay.
And this is intra-district transfer.
Yes.
Representations have been received regularly from different level and types of...
Brother, this is your petition. No, you have it with you.
No, I have
a
separate copy. That
you have got one more copy?
Yes.
Okay.
Representations have been received regularly from different level and types of teachers working in elementary schools for inter-district transfer on various grounds. These have not been considered as no such policy is available. So considering the different issues as mentioned above, government after careful consideration have been pleased to formulate the following guidelines for inter-district and intra-district transfer of teachers of elementary cadre, assistant teacher ex-cadre, and junior teacher schematic, etc., working in elementary schools.
1 second. let us read section 19
and 25 of the Compulsory Education Act.
A and B.
Compulsory Education Act.
Norms and standards for schools.
Yes.
Where can I
Five is the norm.
Yes.
Pupil teacher ratio.
Yes, 169.
No school shall be
You have to
established.
kindly see the manual, 169.
No school shall be established or recognized under section 18 unless it fulfills the norms and standards specified in this schedule. 2. Where the school established before the commencement of this act doesn't fulfill the norms and standards specified in the schedule, it shall take steps to fulfill the norms, such norms and standards at its own expenses within a period of 3 years from the date of such commencement. 3. Where a school fails to fulfill the norms and standards within the period specified under subsection 2, the authorities
prescribed under subsection 1.
Section 18 shall withdraw recognition granted to such school in the manner specified under subsection 3 thereof, with effect from the date of withdrawal of recognition under subsection 3. No school shall continue to function.
And if somebody continues, he will be extended with 1 lakh rupees fine.
That is the penal provision.
Penal provision, my lord.
That is then 25. Your Lordship, I kindly see 25, that is pupil teachers ratio. Within 3 years,
Pupil teacher ratio as specified in schedule.
Schedule 25.
Para 2.
That
class 2, subsection 2.
For the purpose of maintaining the pupil teacher ratio under subsection 1, no teacher posted in a school shall be made to serve in any other school or office or deployed for any non-educational purpose other than those specified in section 27.
Schedule is there, my lord.
Yes, schedule is there. Schedule that
Number
is
of teachers.
How many teachers? Number of teachers for first class to fifth class, then for sixth class to eighth class. Schedule and building other infrastructure.
End of this.
End of the act.
Act, my lord.
Okay.
The schedule, see 19, sections 19 and 25.
Yes.
In terms of that, it is there. Up to admitted children below that, my lord.
Yes.
Up to 60, 2 children, 2 number of.
How many teachers will be appointed as per the pupil teacher ratio that has been provided?
To 90
and so far as infrastructure is concerned, that is also provided in that schedule. Now, my lord, so far as inter-district transfer is not applicable.
Sir,
But so far as inter-district transfer is concerned, although that is not applicable for elementary school teachers, my lord, so far as here, my lord, both inter-district transfer and inter-district transfer, those 2 provisions are there in this policy decision. Your lordship may kindly see, my lord, in what circumstances inter-district transfer can be made. That is on the request A principles. Your lordship may kindly see 2 inter-district transfer. A principles. A. The transfer process shall be conducted only in online mode on a computer-based program. B. The competent authorities shall issue transfer orders only after approval of the same by the state level or district level committee, as the case may be. Then C. Inter-district transfer of elementary cadre teachers will only be considered on the following personal grounds. Clear. My lord, mutual.
Let us read ABC once again.
ABC.
The transfer process shall be conducted only in
online mode on a computer-based
program.
Then B. The competent authorities
shall issue transfer orders only after approval of the same by the state
competent authorities
committee, state level or district level committee, as the case may be.
Yes.
Inter-district transfer voluntary cadre teachers
will only be considered on the following personal grounds. It is not in a regular manner because inter-district transfer is not permissible so far as elementary cadre teachers are concerned. They belong to district cadre. Then personal ground, terminal illness and other things have been mentioned. And that if spouse relating to spouse also
transfer will be.
yes.
Okay.
May I read or?
Yes, I have read that.
Yes. Then
how many cases of inter-district elementary transfer of elementary schools here?
Here there is no inter-district transfer. Only intra.
All
are intra.
Within the district.
Within the district. Now your lordship may kindly see. Kindly come to intra-district transfer principle. Clause 3. Clause 3, intra-district transfer. We are concerned with intra-district transfer. 1. My lord got it?
No. Intra-district transfer.
In my case, at page 30, intra-district transfer. 1. Personal and administrative, within bracket, other than rationalization transfers. A. Grounds of transfer and teachers transferable under different grounds. The teachers of different category may be transferred within the district on the grounds mentioned against each in the following table. Then 1. Employee category. All regular elementary cadre teachers, grounds administrative and personal. Conditionality. No employee shall be transferred from a deficit school to surplus school. This restriction shall not apply to mutual and terminal disease cases. Then 2. Junior teacher schematic. Junior teachers and Ganashikyaks. The grounds is administrative, terminal illness and mutual. Then your lordship may kindly come to the next page.
2 grounds. Administrative requirement, personal representations.
Transfer shall be mainly on 2 grounds, administrative requirements and personal representations. Personal representation shall be on health grounds or other personal grounds. Administrative transfer shall include transfer and rationalization. Similarly, transfer on personal grounds shall include mutual transfers. Then Roman 2. Junior teacher schematic, junior teacher and Ganashikyak shall not normally be considered for transfer except on mutual ground and on ground of suffering from terminal diseases. Mutual transfer shall be considered only between same categories of teachers such as regular with regular of same post, such as level 5 against level 5, level 4 against level 4.
How many cases of mutual transfers are here? According to
No, here there is no case of mutual transfer.
No mutual transfer.
That is another batch.
Okay.
May I read further?
These are all administrative ground transfers.
No, not an administrative ground. Only on the ground of only on the recommendation of MLA and MP. That is the first ground, and in some cases, ex-cadre teachers. Ex-cadre teachers are also not liable to be transferred.
Yes.
As far as ex-cadre teachers are concerned, well, your lordship may kindly see. Kindly come to in my brief, page 28. Clause G.
Clause D.
Clause G. Clause G. Junior teacher schematic. My lord got it. Previous page. Junior teacher schematic. small g. Your Lordship, may kindly see the previous page. Previous 2-3 pages.
Internal page what?
Internal page in my brief at page 28.
No, internal page of the order.
Guideline.
Page 3.
Page 3.
Third page.
Third page. तीन number तो junior teacher schematic, junior teachers, assistant teacher, ex-cadre. We are concerned with assistant
And
teacher.
Ganesha shall not be considered for transfer except on
Neutral ground, on ground of terminal illness. So, ex-cadre teachers are
So they are excluded from transfer.
excluded
How
from.
many of them are here?
Here, my lord, there are number of, in my cases, at least, I will give.
So that we can dispose of them.
Yes.
On this ground,
Mr. Ratha's case, so there.
You applied to with regard to that ex-cadre.
Ex-cadre.
Numbers.
1 second. We'll complete that. One set of people will.
Ex-cadre.
But
Common is MLA and MP. That is the common ground.
Come to that one. That will come down.
And violation of guidelines is.
My lord, where is the power to transfer? Junior teacher schematic, junior teachers, assistant teachers, ex-cadre, and Ganashikyash.
I'm holding the brief of my senior.
Yeah.
That is 2383.
Guidelines.
My lord, yes. That order, transfer order, he is challenging. Lordship, may I kindly.
Which are those matters? Give the list.
Yes, I'm
Give
giving the
list
list.
of the non-transferable teachers.
Yes, my lord, these are all inter-district. It is not applicable for intra-district.
No.
These are, my lord.
My lord, ex-cadre teachers.
Lordship, may I kindly have a look to the approved page 23. A list of approved elementary teachers who are transferred. Not an ex-cadre teacher is there, my lord.
No, there are some, there are cases of ex-cadre.
Ex-cadre
Teachers are not there.
No, now the answer.
Your Lordship, kindly come to page, kindly come to the principle of intra-district transfer.
Mr. D.
Roman 2.
Inter-district transfer, intra-district transfer.
Yes.
Grounds of transfer.
Yes.
Transferable class of teach.
Yes.
These are the four things.
Four things, my lord.
And the committee. Fine.
Committee will decide that, my lord.
Yes. Now, for a committee to decide, he should be in the transferable class of teachers.
Yes, yes. As decided in this resolution.
In this resolution. Now, kindly come to.
My lord, I'm clarifying here. My lord, these things will be decided by a district level transfer committee.
No.
My lord, let's
say.
My lord.
This class or that committee.
My lord, my lordship is right. Lordship, there are two committees are there. One is state level, another
one is
district level. So district level committee will decide the transfers of intra-district transfers.
That is
but the transfers which will be made within the revenue education district.
Whether even within the district,
yes,
there is a class of teachers which cannot be transferred at all.
Yes, my lord.
Those cases, we can dispose of saying that you have no power to transfer them. One line out.
Yes, my lord. They are, my lord. So far as inter-district transfer is there, it is at the director's level.
No, I'm not on.
My lord. So far,
there are, see, there are, there is a class of teachers.
Let's kindly turn to page 31. Page 31, the principles.
That G is inter-district. And the extra provision is available for inter-district as well. At clause 2.
No, I am asking.
Clause 2, Roman 2.
in intra-district transfer,
Yes.
whether some teachers are exempted from transfer.
Yes.
Clause 2.
Clause 2.
Clause 2.
The clause Roman 2.
My learned senior.
Roman 2.
May be
Roman 2.
permitted only 2 lines.
Roman
From
2.
this, what he has stated to my lord. There are 2 types, intra and inter. Intra also there is a bar. Can you see that?
That is Roman 2.
Separate principle has been laid
Well,
for
for intra.
Yes.
for as well.
Yes.
We are concerned about intra.
Clause 3.
Yes.
Yes.
60 governing intra-district transfer principles have been delineated.
Page 31 of the
Roman 2. 31.
Roman 2.
Teacher schematic. Your Lordship may kindly see my brief.
That is the only point.
6th page of that guide.
Pilot.
In my brief, page 31. My brief.
Shall I read that? Yes.
What's my hold it?
Anyone?
Junior teachers.
Schematics, junior teacher and Ganasikha
Shall not
normally be considered for transfer
or transfer
except on mutual ground
mutual ground.
and on ground of suffering from terminal diseases.
Exactly.
Yes. That is the point.
Say, junior teacher schematic, junior teacher and Ganashikshan are not transferable at all.
Yes.
Is your proposition.
Yes.
Who controls this proposition?
I am. Normally, the term Lordship, they said, these teachers, they shall not they shall not normally transfer. Yes.
Normally is there.
Well, means the norms are laid down.
Yes.
In these norms, it is not.
Yes.
It is not the word ordinarily.
Yes.
The word used is normally. Supreme Court has interpreted what is meant by normal.
Yes.
But by norm. By norm, you are not transferring.
Yes.
Assume for a moment. Some teachers misbehave. I am giving it.
Yes. Illustration.
Not example. Illustration.
Yes.
Some teachers misbehaves with the colleague.
Yes.
Or student. That is not provided for the transfer.
That can be done on administrative grounds.
That can be done
on administrative grounds.
That's very clear.
That is not there. But administrative and so far as administrative ground is there in the transfer policy.
These people are exempted even from administrative ground.
Yes.
Therefore, there are cases which should fall divorce these provisions.
Yes, absolutely correct.
But that cannot be here. It's another.
Yes, another.
Administrative ground is there.
Yes, I am saying so. I am saying so. Administrative grounds are there.
Which administrative?
My lord, it is there at in the intra-district transfer.
Yes, that is there. That is there.
1A. It is there.
That is there.
1A. It is there.
1A.
Yes.
Order of priority.
Order of priority. Administrative.
Administrative ground. B personal ground.
Administrative, junior teachers, schematic, junior teachers and Ganashikshyaks. Administrative, terminal illness, mutual. No employee shall be transferred from a deficit school to a surplus school. The restriction shall not apply to a terminal disease cases. My lord, here is a term schematic is there.
Kindly see.
Schematic term is there. So it in paragraph 2. It is written, my lord, junior teacher, schematic, junior teacher and Ganashikshyaks shall not normally be considered for transfer except on mutual ground and on the ground of suffering from terminal diseases.
My lord, may kindly come to order of priority. A, administrative ground. B, personal ground. Mutual, terminal diseases.
No, they are not.
Yes. Then within the above priority cases, within the above priority cases, the employees will be listed in order of their date of joining as regular teacher, headmaster, assistant teacher, ex-cadre, junior teacher.
I want to read out the class of cases now.
Yes.
The cases, they fall in the class of non-transferability.
Yes.
normally non-transferable.
Yes.
Those cases also have suffered transfer.
Yes.
They have to go.
Yes.
But they have to give list so
That's
that.
fine. That's fine.
Yes, I will give you.
Finish up them first.
Let
Then
them,
remaining cases.
my lord, remaining cases, we shall decide on merit. Let them.
Remaining cases with regard to the MLA.
MLA and MP.
That's all. That's the only point.
That is the only point.
Another 10 minutes.
Yes, ma'am.
Yes.
Lordship, give them the list of cases so that it can be.
Which are those cases?
Yes, my lord, I am giving the list. These are ex-cadre.
Whatever list kindly give me a list so that I can.
Just verify you.
Yes.
I'll give dictation.
My lord.
In all these cases, is this one? The transfer means the challenge is to the intra-district
Transfer.
transfer order of various names. First, learned counsel for the petitioners.
Well, in addition to the MLA MP ground, that ground is there.
No, they may not go to that at all.
When the principle is there, why should we?
Yes.
For other things, we do that.
Yes.
See why it says a constitutional court will not decide points that would not otherwise arise before it. And if it can be decided on a particular point, on that principle, before the issue. In all these cases, challenge is to the intra-district transfers by virtue of impugned orders of various information. Learned advocates appearing for the petitioners submit that under the extant guidelines dated
14/5/2025.
Promulgated by the state government. In the light of sections 19 and 25 of the RDA Act 2009,
compulsory.
These teachers are exempted from transfer as a matter of law, and that only in extraordinary circumstances they can be transferred. First of all, they add that there are no such extraordinary circumstances revealing from the record. First, next one. Learned APA Mr. G, per contra content, that all employees, regardless of the transfer guidelines, are liable to be transferred, and therefore the ground urged by the petitioner is not sufficient to invalidate the subject orders of transfer. Next one. Having heard the record of the first party and having perused the petition papers, this motion is inclined to start indulgence in the matter in as well as under the extant rules, guidelines. These teachers, this class of teachers is normally excluded from transfer, be it agony or ecstasy. First of all, the relevant paragraph of the guideline, transfer guidelines, reads as a is 31 small skills. Next paragraph. Look at the he's right in saying that no civil servant like the petitioners can claim complete exemption from transfer, whatever be the circumstances. First, however, there should be extraordinary circumstances for taking the cases of non-transferable employee out of the transfer guidelines. First, no such extraordinary circumstances are provided in the transfer order, except stating that it is for administrative rationalization grounds.
Here, can I interrupt little? In this my lord case where my senior is, first case, senior is arguing, probably he has no case at all. Because of the fact that all the teachers are Ramdas Soren, all the teachers transferred approved list, all are assistant teachers. They are not schematic.
This is not this case.
No. He's a extended teacher. He's a extended teacher.
No. So then kindly have a look to the prayer. Prayer first, your Lordship may kindly have a look.
Verify and come.
Let me
Verify and come.
The above circumstances, whatever, if you find out,
yes,
be excluded. In the above circumstances, these petitions succeed and impugn the orders of transfers or request by issuing a writ of censure. Now there is another problem. We are in
MLA
almost December. No, we come to that time to 2 o'clock. Now, if we say that those who have already been working there, we can restore them in the next time.
No, interim order is there.
Wherever stay order is there, they're moving protect.
In all cases.
Wherever you have joined, there we cannot cause damage to the children. Therefore, immediately after the academic year, they will be brought back to this.
Where
the person continuing.
Yes.
Wherever interim orders have protected the same benefit will continue to them. First one. However, wherever no interim order has been granted, as a teacher concerned has already
been relieved,
reported duty at the is relieved from the school, or joined the transferred place to the transferred place at the transferred place, he or she shall be restored to the original positions only after the end of this academic year.
Can I pray, my lord?
Yeah.
Lordship may say that this order is applicable to the only schematic posts, only ex-cadre. Schematic.
Yeah, that this order is applicable only to the schematic posts.
Schematic and
ex-cadre.
Posts and ex-cadre.
Persons continuing as ex-cadre and schematic posts.
Continuing. Yes,
Not to the regular assistant.
Not to the regular.
The regular cadre.
Yes, regular assistant. Regular assistant. Regular assistant.
Regular cadre teachers.
Other
matters after lunch.
Okay, I'll check for you.
Yes, sir.
Pardon to mention, small player before item 49 is a student's consent matter.
Students.
Yes, Your Honor. You kindly take it in as a friend submission, Your Honor. I have also filed one IA.
Question when?
Result has been withdrawn by the offense.
It's based. Yes.
Result has been withdrawn, Your Honor. So, this is small, very
Any
small.
urgency?
They have to forward to the next semester.
When it was?
That is item 59, Your Lordship. They have to inform of October.
In the list today?
List today.
You want it to be taken today?
Yes.
I'll try wait. Otherwise, short date will.
Yes.
That SR notice has come now.
Huh? Those matters have come.
Yes.
We'll take after this. Yes.
But so far as,
Item 47?
yes, so far as
The
MLA.
other matters you are taking up now.
My lord.
Other matters are said, these matters are disposed of.
Yes, then other.
Have you seen that list?
Yes, yes.
My lord.
Are you agreeable with that?
One thing I want to apprise your lordship, the teachers, those who were regularized from amongst the Gana Shikshakas, but ex-cadre, my lord.
Level 5 ex-cadre.
There is no, that has been withdrawn. They were brought over to the regular cadre teacher under elementary cadre. That is the.
No, not
Where did they
withdrawn.
show that?
Not
By
withdrawn.
construction, Supreme Court.
Supreme Court order, my lord.
All these
Ex-cadres were regularized.
from 4-5 to.
No.
But yes,
They are
that
regularized
is
from 4, 5?
2000. I'm serving.
No, to them it will not be applicable.
Yes.
Lordship.
You have made it clear, na?
Yes. Yes.
Mr. G,
It was.
this order I have made clear.
Yes.
Only
Those who were.
Only applicable to ex-cadre.
Yes, those who were regularized and placed under elementary cadre, this order is not applicable to them.
Yes. Yes.
Pilot order.
that must be
It is made clear that those who have been regularized
And brought over to their elementary cadre, regular elementary cadre.
brought over to the regular elementary cadre, comma.
This order is not
This
applicable.
order is not applicable.
Yes. Yes.
That was of this. Yes. The small list I have given. That should be there.
But so far as my.
Matter repetition 30,666 of 25. I am appearing for on behalf of the OP number 4. That repetition concerned that OP number 4 has not proposed to be transferred to that place now. So the petition may be disposed of on that line.
As having become infectious.
Yes, sir. Because the petitioner challenged my order. I am the OP number 4, and after getting notice from the Hon'Ble court, I am a regular teacher of high school.
You are respondent.
Respondent 4.
OP number 4.
OP number 4.
Which, who is the petitioner in that?
Ramdas Acharya.
Now bring him at least. Ramdas.
Yes.
Mr. Ramdas, he is saying something, just consider.
I am OP number 4. I appeared today, and he made a grievance against me that I appeared, and receipt may be taken into consideration that I have no objection. If he is continuing, I am also continuing in my post, madam.
What do you say? If both they are agreeable to continue in each other's place, is it on a mutual transfer?
No, my lord.
It is not mutual.
No,
That is
Then both of you cannot override the decision of the court, the government.
by the order of that MLA.
Huh?
That MLA recommendation order.
That we will hear. Wait.
Yeah, that.
Yes. Let us see.
Well, it's super.
Necessary.
Will your lordship hear that matter now or
Yes,
any day?
I'm hearing that.
Well, so far as MLA and MP matters are concerned. Well, your lordship may kindly see the circular dated 13/5/2025.
Which are the matters now disposed of? Just give the numbers. I will round off in my list.
Well, I have given.
This is 47, na?
Yes.
In 47, just mention which are those.
Well, 23834 of 2025.
1 second. 2, 3. Just mark that with the
23834.
Hey, tomorrow ଗୋଟେ ଅଛି ରଥ ଏଇଟା ପରା 23307 23307 ଗୋଟେ ଅଛି
Well, I have given the list.
Already given.
एक्सपेक्टर कोण काही आहे भाई.
Yes, sir.
Yes. My lord, may I kindly take up WPC number 23838 of 2025. Yes. 15.
Yes, sir.
My lord, may I kindly come to page 23.
Give the serial number, give the WP number.
That is WP number 23838 of 2025. Ticket ho bhai. 23838 of 2025.
23838 of 2025. Please give the list, the hard copy.
Your lordship, may kindly see the government circular dated 13/5/2025, which confers power upon the MLA and MP to recommend for transfer.
Yes.
I'm just.
Why MLA MP should not be included?
Yes.
Knowing the requirement of their public education.
Yes, my lord, I'm coming to that.
Yeah.
I'm coming to that, and I will cite decisions also.
Yes.
Your lordship, may kindly see the tenor of that government order. I am directed to say that government, after careful consideration, have been pleased to give discretion to honorable MPs, MLAs to recommend up to.
Where are you?
But that is government order dated 13/5/2025, page 23.
Not 14/5.
Not 14/5.
Then I have to return this brief to my friend. This is 14/5.
That is also there.
That is also there.
Also there.
13/5.
13/5/2025.
I'll just get it for your lordship.
Yeah.
Convenient.
I have made a yellow mark. Sorry.
Yes.
In your
I'm just
petition.
giving it. Right now I'm giving it for your lordship. But it is there before that.
In your page.
Page 23.
Annexure 3.
Annexure 2, page 23. Annexure 3, page 23.
What?
I have got it. My lord, may kindly see that order. Subject regarding transfer of teachers. Sir, I am directed to say that.
Who has issued this?
This order has been issued by the Joint Secretary to Government.
Joint Secretary to Government.
And so far as the government notification dated 14/5/2025, that policy decision that has been issued by the governor.
That is issued by the governor.
Governor.
That is
as per rules of business.
That is
by order of governor, commissioner come secretary to government.
Their committee is formed.
Their committee is formed.
That committee comprises of MLAs.
No. Your lordship, may kindly see
the transfer guidelines dated 14/5/2025 are purportedly issued under section 19 and 25 of the RTA Act. First off, it inter alia provides for a constitution, the constitution of a committee for counseling. Counseling or
no, not counseling, but for transfer.
For recommending the transfer. First off, the committee comprises of
the committee, so far as district level committee is concerned, that is
collector.
That is, yes. District level committee is concerned.
One is district level committee. Another is state level.
Page 33. Collector and DM of the district chairman.
First off, the district committee comprises of the collector as the chairman.
District project coordinator, RT.
District project coordinator,
RTSSA. As member. All block education officers of the district member.
And all block education
officers of the district as members.
Concerned as members.
Then district education officer, member convener.
And district education officer as the member convener.
Member convener. So far as the state level committee is concerned.
Who it takes the decision? By majority. Anything is given, indicated.
Committee will take a decision. Committee will take a decision.
Take decision.
Yes. But so far as
state level committee comprises of
director, elementary education as chairman,
elementary education as the chairman,
joint director as member,
joint director, and all other,
and a deputy director elementary education nominated by director elementary education as member.
Deputy director of elementary education
nominated by
the director
as member. Then deputy director administration of SPD.
Deputy director
administration SPD state project director USEPA as member, and deputy director elementary education dealing with elementary teachers transfer as member convener. Member convener.
This is
Deputy director elementary education dealing with elementary teachers transfer as member convener. Page 28. My lord, now your lordship may kindly come to that.
These guidelines have been promulgated
under RTI
by the governor of the
by the governor of the state.
Governor of the state.
My lord, so far as the government order dated 13/5/2025, which has been issued by Joint Secretary to Government, empowering the MLA and MP to recommend for transfer. Your lordship may kindly see that tenor of that order.
This is more like a letter.
More like a letter.
It is a letter only.
More like a letter. And there are certain principles also. Your lordship may kindly see.
They cannot give. They cannot give the any number of teachers.
No, 15. But beyond 15, they have done. One. I am reading it entire. I am directed to say that government, after careful consideration, have been pleased to.
The government policy.
Government policy is 15/5/2025.
No. He said,
yes,
I am directed. By whom he is directed?
I am directed to say that government, after careful consideration.
So government direct.
Government directs.
That government decision.
What is the government decision?
That government's decision.
Get it by WhatsApp.
My lord, it will take some time.
Before we conclude the hearing. Let us see whether he gives that letter on his own.
No. It
there must be some government.
Some decisions have been.
They took that decision.
My lord.
Science.
To say that government, after careful consideration, have been pleased to give discretion to honorable MPs, MLAs to recommend up to 15 most deserving cases of transfer of teachers that shall include both elementary and secondary pertaining to their constituency area to the concerned collector of the district for disposal of the same by the district level transfer committee during this transfer session, subject to the following conditions. 1. It should not violate the principle of rationalization. 2. Priority should be given to the teachers with urgent need. 3. No teacher should be transferred from rural area to urban area. 4. This discretion is applicable for intra-district transfer only, not inter-district. 5. The proposals of the Honorable MP, public MLA, are to be submitted to the concerned district collector and will be disposed of by the DLTC, where the parliamentary constituency covers more than one district. The proposals will be submitted to the nodal collector, returning officer of that PC, under intimation to other collectors within the jurisdiction of that PC, for disposal by respective DLTCs. In case of Honorable MP Rajya Sabha, the list may be submitted to the Director Secondary Education under intimation to the Director Elementary Education. The DSC, Director Secondary Education, will forward the list to the respective collectors under intimation.
This is for as a one-time measure.
One-time measure.
One-time measure.
Your Lordship may kindly see para 6. All the proposals, this is important. All the proposals.
For session 15th May.
15th May to 15th June only. And thereafter, Your Lordship may kindly see the government notification dated 14/5/2025, which has been issued under the RT Act. All previous circulars, including that has been superseded. My Lord may kindly see that. Page 34 of my brief. 8. Repeal. My Lord got it. This notification supersedes all previous notifications issued by School and Mass Education Department in this regard.
This is issued by Commissioner cum Secretary to Government.
Yes. By the order of the government. So 13/5 is also gone by virtue of this notification.
No, it is not that. It is relating to transfer. It is.
You will reply. You will give your reply. But so notification is gone. According to me, subject to your Lordship's acceptance. Then, my Lord, the date line.
1 second. Which is this notification?
Notification 14/5, which is issued under the RTA Act.
But
that is the policy relating to transfer.
No, these notifications are.
This is not a notification.
This is not a notification.
This is not a notification.
No, this notification means 14/5/2025 notification. Supersede all previous notifications issued by the School and Mass Education Department in this regard.
Correct.
Yes.
The
previous order, my Lord is saying that previous order is not a notification.
What to?
Rules of business.
General Clauses Act. Whether the word notification is defined.
Includes
General Clauses Act.
Includes any circular of the state government.
No.
Any government order.
Notification, it appears they are defined. At least there are 2 judgments of 2 high courts,
yes,
which
notification.
This is Central Act. Where is the State Act?
State Act. State General Clauses Act is there.
Orissa General Clauses Act is there, na?
Yes.
So the General Clauses Acts are not taught in your universities?
Yes. Yes.
Are they taught? Dr. Chodi, you should be in a position to answer any question arising in the court within minutes. Your doctorate.
He is a part-time lecturer in the university also.
Then within seconds.
But there is a delay in this website.
No, you should be knowing all that. We need not go to this computer, etc. It should work. Brain should work as computer.
Because he used to teach.
Notification in the Gazette. Notification in the Gazette. Notification means under the Odisha General Clauses Act. Notification means it is notified whichever it is notified in the official Gazette.
That is section 28(2).
Yes.
Of Odisha General Clauses Act.
Read.
Definition but 2 or 28.
2 or 28. Sorry, 2 or 28.
Subsection 28 of
subsection 28 of section 2.
228.
228.
Notification. Hey, 1 second. Why are you going so fast?
A notification shall be a notification in the Gazette.
Notification in the Gazette. Therefore, obviously, that is not included because it is not published in the Gazette at all.
So that first letter of that empowering the MLA and MP. Yes.
It cannot go beyond that also.
Under which provision?
Yes.
This is an immediate question to you, which you may take a few minutes to answer, but I am alerting you.
My lord.
Under which provision of which act this notification, this
letter was issued? This letter was issued.
What do you call it as? Letter, order?
My lord, it's a letter.
Notification?
It's a letter.
Letter. How can the business of the government be run by letters?
It's an instruction to the field officers.
Oh.
It cannot.
Yes, it cannot override
It has no effect whether the 10 Lordship may kindly have a look what it has written. It has written that they will recommend.
Formulates a policy.
Well, it is not beyond the policy.
No,
it is not.
Policy.
It's a policy.
Because you are constituting the committee.
Yes.
You are putting the norms with the committee.
Lordship is right. Here, what they are saying? They are saying that the so and so pertaining to their constituency area to the concerned collector of the district. District means to the chairman of the DL's district level transfer committee. To the committee they will recommend. Committee will decide. It should not violate.
That's all.
My lord.
They are not members of the committee.
No, they are not. My lord.
That is not his case also.
And while also does not empower the MLA and MP.
My lord, while considering their cases, the committee will look into all these criteria. One is, it should not violate the principle of rationalization. Priority should be given to the teachers with urgent need. All these things.
That is a letter.
Yes.
How these officers will respond to the MLAs and MPs? Our common sense we have to keep in mind now.
My lord, your lordship may kindly remember there was an amendment to the constitution in the year 1973, 73 amendment. There, the constitution empowers the panchayats to take care of the primary education, secondary education, etc.
Correct.
The public representatives are there too.
73, Article 243.
243. It empowers them. My lord, they are the representatives. Their constitution empowers the sarpanch. But it is not possible for the sarpanch to approach the collector. That's why, my lord, the MLAs, MPs, Rajya Sabha members, they were empowered. They will collect information from the sarpanch, and thereafter they will inform the.
Come to right to education, right to children, right of children to education.
My lord. Sorry.
Come to section 27.
27.
Read 27.
It is no teacher shall be deployed for any non-educational purposes other than the decennial population census, disaster relief duties relating election
to the local authority, state legislature or parliament.
as the case may be.
There the problem comes. Teachers can be engaged and they are being engaged for election duty.
Exactly.
Suppose if in order to take advantage proximity to the MLA MP,
my lord,
or to advance a particular viewpoint of a political party,
my lord,
if teacher starts doing it, because this MLA says, whenever you go for any house, just look into mine, just tell them to put their vote to me.
My lord.
That will happen. In election duty, the teachers are involved by virtue of this statutory provision. Although Supreme Court said ordinarily they should not.
There should not be.
But the section says like this.
My lord, the section
judgment.
No teacher shall be
ordinarily teacher should not be drawn for election duty. Now, if unscrupulous candidate,
my lord,
tells the teacher, whenever you go to election duty, canvass my point of view, my candidature.
Their, my lord, their placement is there before the election booth, polling booth. In case of
election duty.
I'm citing a judgment.
Yeah,
Yes.
there is a judgment. In fact, the chapel occur in law of election. It means what
this
are
is-
the duties of the election.
This is a judgment of Sri S. Venkatastapa from the Karnataka High Court. It is there. That's it.
Venkata?
Recent judgment of this
Supreme Court.
No. It's a Karnataka. Yes. So their lordship has held that the MPs, MLS can also.
No, that's all right. And this section is not considered.
My lord.
This section is not considered.
Not considered.
I am asking if teachers are reaching that judgment, which says there is one more provision in Representation of People Act 19. Representation of People Act 1951.
51.
Or 1950. There are two statutes. Representation of People Act 1950, Representation of People Act 1951. There is one provision which authorizes the Election Commission of India. Read section 27A or something like that. RPA, give RPA. Yes. The Election Commission can draw any officer of the state for election work.
It's a case of transfer, my lord.
There is one section. With the section? No, not that. If the Election Commission can draw any state officials for election duty, there is such a clause, such a section. Which act, there were not the two acts.
28 for us tells you about returning officer in the discussion with the election commissioner to bring those officers to under his control.
Section
28A speaks of returning officer lordship.
Of which act?
RP Act 1951.
Two acts.
RP Act 1951 lordship.
Section 20. 28.
Returning officer, polling officer deemed to be in deputation of election office commission lordship 28A.
28A.
The returning officer, assistant returning officer, presiding officer, polling officer, or any other officer appointed under this part, or any police officer
Designated for the time.
which shall be deemed to be a deputation system. No, not this. No, there is a provision which empowers the Election Commission of India to draw the state officials for the election duty.
That is also their lordship. If they have book, they can
Yes,
get pointed.
take our book and leave it with us.
Lordship. My lord, according to transfer law, my lord, transfer is always made within the cadre, my lord, one place to the other, within the same scale, same post holding. There is no allegation that somebody is getting some lower scale or lower post or some higher post. It is not the case of anybody. It is also not the case, my lord, in terms of we have violated certain rules as
where is the authority?
My lord, we have not violated any law.
No, not
because
question is not.
the circular government circular, whatever it is there in the 13/5/2000, it is government circular, my lord.
No, why this letter?
This is 14/5/2000.
No, 14/5 we can.
14/5. We have not violated that. We have not violated any rule.
No question.
But, my lord, lordship may kindly have a look to the judgment passed by the Honorable Supreme Court. My lord, I'm coming to that.
We have a specific question to you.
Where do we get power that to issue that letter?
Yes.
My lord, that is an instruction issued to the office that one can give such a subject to a verification of the district level transfer committee within the stipulations given in that letter, my lord.
To give that letter, where is the power? Government, our constitution envisages a limited government.
Yes.
A limited government means government will act in accordance with laws.
My lord, yes.
And by laws.
Yes.
Where is the legal authority to the government?
So
this instruction.
My lord, so I humbly submit, my lord, I am referring to a judgment of Shilpi Bose and others versus State of Bihar. Transfer matter. That is the leading to me, my lord. That is a.
To accommodate one person, you cannot transfer is the ruling.
I'm placing that and paragraph 4.
192, so 91 Supreme Court.
It is for 90.
90 Supreme.
On 91, it was reported. My lord, in our opinion, the court should not interfere with a transfer order which are made in public interest and for administrative reasons unless the transfer orders are made in violation of any mandatory rule or on the ground of malafide. A government servant holding a transferable post has no vested right to remain posted at one place or the other. He is liable to be transferred from one place to the other. Transfer orders issued by a competent authority do not violate any of his legal rights. Even if a transfer order is passed in violation of executive instruction or orders, the court ordinarily should not interfere with the orders. Instead, affected parties should approach the higher authorities in the department. If the courts continue to interfere with day-to-day transfer orders issued by the government and its subordinate authorities, there will be incomplete chaos in the administration, which would not be conducive to the public interest. The High Court overlooked these aspects in interfering with the transfer orders. Their Lordship, I am citing this judgment.
He banks upon certain observations in Shilpi Bose versus State of Bihar to the effect that in matters of transfer, the High Court should not, as a matter of course, should not as a matter of course intervene.
First, my next point is
one by one. That's what I want to have. I'm just making my mental.
Yes.
That was a case of executive instructions.
My lord, that is also a case of a primary school teacher.
Question is not that.
My lord, here
if it is executive instruction, then violation, even if there is violated, nobody can come to the court and complain. Because of State of Mysore versus Fernandez, 65, 66 or 68 judgment. If it is executive instruction, a decision, this is what we have been taught in law of precedence. Great professor Desai and J.S. Patil, they used to teach like this. There is difference between executive instruction and the instruments of law.
Yes, my lord.
These executive instructions are issued ordinarily under Article 162,
yes,
of the Constitution, which apex court has considered in 3 judgments. One is Lakshmendra Tirtha Swamiyar versus Hiteshari Commissioner. 54 Supreme Court, 1954 Supreme Court. The other is Kharak Singh versus State of UP, 1964 or 65 Supreme Court. The third one is Bijo Emmanuel versus State of Kerala, 1986 Supreme Court. What is difference between executive instruction and instrument of law is discussed by the apex court in these three instances.
My lord.
This is number one. Shilpi Bose is structured on executive instruction. That word appears in the judgment which you have read now.
My lord. That I have cited, the lordships.
Yes.
And also cited a judgment of.
No, I am analyzing it.
Yes.
So that I can have some answers from
my lord.
These guidelines of 15/5/2025.
Yes.
I've got
14/5. Yes. 14/5.
No, 14/5.
14/5. 14/5 is the guideline. Yes.
Are relatable to 19 read with 25 of the RTA Act.
Lord, read with Article 166(1) of the Constitution. You lords may kindly see that provision as well.
166(1)?
Yes.
Read.
My lord. All execute. This is the marginal heading is
That is how they will be expressed
exactly
by the governor in the name of etc. etc.
Your lords may kindly mark page 34 here under.
But that is held to be directory.
I'm reading it, my lord.
No. It is interpreted by the apex court as being directory.
My lord, your lords may here, my lord. The executive instruction dated 15/5/2025 conforms to the very same requirement of what? Yes, that is what I want to point it out. You must kindly mark. Here it says all executive actions of the government of a state
shall be expressed in the name of and the order of the governor.
Here it has been said, your lords may kindly find that at the last part of that particular circular dated 14/5/2025, there is a mention by order of the commissioner cum secretary.
Correct.
So this confirms and automatically gives the status of executive instruction to the very same letter dated, to very same office memorandum dated 14/5/2025, which the previous notification dated 13/5/2025 lacks. Because 13/5/2025 has not been addressed in the name of the governor, and rather it was yours faithfully by
your secretary to government.
It is only a letter.
It's
only a letter only.
It's
so
only
that
a
is an executive instruction. The previous one is a letter.
Got the point. There is that apart. The 14/5 is a statutory instrument.
Statutory instruction. Yes. That is the.
He agrees.
Yes.
All fair.
Because
19 and 20.
Because no. It is
Itself is governed by a 309 rule. That is Orissa Elementary Rules. 1997. It has been framed with proviso to Article 309 of the Constitution.
Lordship may kindly have a look to the last line of the order, my lord.
Order means
that no 14/5.
14/5
notification.
Is it published in the notification?
Yes.
Yes.
Order that it is there.
14 is published, but it's not
notification.
14/5 was not.
It is a letter only. Lordship, it is there, Lordship. This notification.
You not may kindly mark.
That order last portion. Order that this notification shall be published in the extraordinary issue of Odisha Gazette.
Page 24.
Page 34 of my brief.
Yes, Mr. G. Now you are saying that Shilpi Bose is on executive instructions.
Yes.
It is on par with which is the state of Karnataka, Varadha Rao versus state of 86 Supreme Court. It is on par with that. But where from her? The transfer guidelines are statutory. Then they become justiciable.
Yes.
There is such a judgment. Just take out the Chandru versus state of Karnataka. A 3-judge bench of our Karnataka High Court. This is also my court. Is another. Don't say.
No, my lord. I'm just referring. This is what I want to submit.
Consider this aspect.
My lord, what I want to submit before your lordship, since the notification dated 14/5/2025 was notified in the Gazette, My lord, it's an instruction, my lord. Transfer has to be made in accordance with the notification.
By whom?
By the district level transfer committee, as mentioned in the notification dated 14/5/2025. Yes.
District level committee comprises whom?
District level committee comprises, my lord.
A, B, C, D.
Yes.
Where does MLA and MP come?
They are not. They are not.
But you are influencing them.
No. What they have said, my lord. In the letter, they have said that MPs, MLAs recommend.
No, that means what?
They will only.
If
They are not the authority.
Recommends.
No.
Officer will do.
No. They will only recommend.
We are in Plato's Republic.
No, my lord. They will only recommend the names. Thus,
therefore,
matter ends there, my lord. But the committee.
Mr. G. We are not in Plato's Republic. We are in Republic of India. If MP or MLA recommends, can these officers say no?
Yes, my lord.
Is it? No.
Because,
say that?
Because, my lord, if these norms will not satisfy, recommendation doesn't satisfy these norms, that's why they have given certain norms. They have to.
Mr. G insists repeatedly that the 13/5/2025 letter is compliant with the 14/5/2025 notification and that it is open to the jurisdictional officers bar committee.
Yes, district level committee or
to ignore the recommendation of MLAs for MPs, even if made.
If they violate, if it is violative of these conditions laid down in the 13/5/2025 or the gazetted notification, the conditions laid down.
If such a recommendation run counter to what is stated in the 14/5/2025 notification.
And also 13/5/2025.
No, 13/5 is a
letter.
13/5 is the letter.
In that letter, they have given certain conditions.
Correct.
They have to satisfy those conditions before recommendation. They cannot suomoto give A, B, C, D as names. No, they cannot.
In any way.
And that is also contrary to notification dated 14/5/2020.
In any way, the letter gives abundant scope for influencing the statutory committee.
Maybe, my lord, that I cannot say that I cannot presume that.
May I interrupt? According to Hon'Ble Supreme Court in the judgment, Mohammed Masood got the state of you.
That has been dealt with in that Karnataka's case.
Masood.
That has been dealt with in Karnataka's case.
In your opinion, even if the allegation of the appellant is correct, that he was transferred on the recommendation of MLA, that by itself would not vitiate the transfer order. Next, after all, it is the duty of the representative of the people in the legislature to express the demands of the people, and if there is any complaint against official, the state government is certainly within its jurisdiction to transfer. There can be no hard and fast rule that every transfer at the instance of MP or MLA would be vitiated.
They have not seen the provisions of RTE Act at all, the provisions of Representation of People Act at all. Representation of People Act prohibits any officer drawn to the election duty being influenced by MPs and MLA or the candidate. There is such a section. I just read it. That all that they are not looked into. They're simply gone. That all our popular representatives will be godly people. It is not like that.
Finally, my lord, lastly, my lord, in that gazette notification that is in 14/5, my lord, there is a provision of appeal and review. if anybody is aggrieved by such an order, the Director of Elementary Education Odisha shall be the appellate authority to dispose of the grievances related to the inter-district transfer and intra-district transfer of the teachers. The director shall also have powers to review and modify the inter-district transfer. All this, if anybody have any grievance, then he can approach the director preferring appeal, or in case of intra-district transfer, and review in case of inter-district transfer. Problems are there, my lord.
Mr. G submit next. Mr. G next submit that the 14/5/2025 notification provides for departmental appeal. And if any teacher is aggrieved by the transfer made pursuant to recommendation of the committee, he can avail that remedy. Thus, there is in-house corrective mechanism which will take care of whatever errors that happen. Should the committee be unlawfully influenced by the recommendation of people's representatives.
But my submission.
That's all.
But my submission is.
Yes, complete.
Yes, completed.
That's all.
Any other contention?
My lord. Thereafter, clause 6 is also there. An authority competent to transfer a teacher can transfer the teachers within 16th June. That is not relevant. That's true.
Lenka interjecting submits that the Karnataka High Court, the division bench of Karnataka High Court in WP 3612 of 2025 has observed that the people's representatives are entitled to recommend a transfer of public officials, including the teachers of government schools, and that a transfer effected on such recommendation is not vulnerable for challenge.
Another judgment I had cited, the Karnataka High Court's judgment. I had that. That's in a kindly. Take note. Yes. Take note of that.
Citation is given?
Yes. I had given the judgment, copy of the judgment I had given.
The judgment copy, I got it. But the citation, do you have citation?
No. Judgment. Photocopy of the judgment.
No, photocopy I have got. This judgment you have given? Citation, mode of citation.
That mode of citation.
Neutral citation you can put for this.
No, mode of citation. Judgment copy of the judgment. Yes. Okay.
Yes, sir.
Well, my next submission before your lordship is, I will take your lordship to the judgment subsequently. Your lordship may kindly see the government order.
Yeah.
Your lordship may kindly see the government order dated 13/5/2025, which empowers the MPs and MLAs to recommend 15 most deserving cases of transfer of teachers. Well, there is, even assuming for the sake of argument, this has been issued under Article 162 of the Constitution of India. It's not a statutory instruction nor a notification published in the Gazette. Then also, your lordship may kindly see para 6. All the proposals should be submitted and disposed of during this transfer session, that is 15th May to 15th June only. But here, recommendation has been made beyond that.
Despite that transfer.
And another
says for in appeal.
No, your lordship may kindly see. so far as the transfer guidelines itself, which is issued under the RT Act, which says, well, your lordship may kindly come to page 34. Para 6, competent authorities. An authority competent to transfer a teacher can transfer the teachers within 16th April to 15th June or the last date fixed in calendar contained herein or notified by government in a year, whichever is latter. That means by 30th June. During the rest period of the year, the teacher can be transferred only by the order of the next higher authority. But director. And here your lordship may kindly see, so far as district level transfer committee, intra-district transfers are concerned, the district education officer is the competent authority to issue transfer orders. That is at page 33 of the guidelines.
15.4.
Roman, yes.
14.5.
14.5, Roman 12. The district education officer shall issue orders for intra-district transfer. Since it has been made beyond that period, the order issued by the district education officer is without any authority, without any jurisdiction, because the director has not issued the order in none of the cases.
Only director could have issued the order.
Director could have issued.
Explain a bit that the transfer is described in the 14.5/2025 guidelines. Beyond the prescribed period, it is competent only for the director to effect transfers. Whereas in all these cases, the transfer is effected not by the director, although they are beyond decision.
Yes.
And therefore are without jurisdiction.
And your lordship may kindly see the guidelines 4A. In respect of both inter-district transfer as well as intra-district transfers, there is a table. My lord, the issue of transfer orders by 5th June, the joining of teachers by 15th June.
That period is what?
But period for issuance of transfer order in that particular...
Between 5th June to?
5th June. By 5th June. 15th. By joining of teachers by 15th June.
That is only 15 days.
Yes.
So 10 days.
Only 10 days. Well, a process will be started from 15th to 30th April. The first column is teachers to submit application.
Teachers to submit application on the
portal.
This is on application it is.
Yes.
Other than application?
Forwarding the proposals by BO to DO 10th May. Forwarding of proposals to the director 20th May. Approval by director elementary education 25th May. Publication of transfers in OSEPA website 31st May. Issue of transfer orders 5th June. Joining of teachers 15th June.
That is on application of the teacher.
That is the heading to submit applications on the portal.
Without applications also they can transfer.
No, without application they can also transfer. But they cannot.
More like a request transfer.
A request transfer.
But other than request transfer also it regulates.
So far as para 6 is concerned, the cut-off date is 30th June. And all these orders have been issued beyond 30th June.
15th
to 16th to 15th June.
My lord, kindly see page 34. That clause 6.
Clause 6.
Clause 6 is clear. Just
on authority.
Just before clause 5, the last table. Implementation of the decision of the DL district level transfer committee and joining of the teachers in their school.
10th June.
10th June. So by 10th, they are perceiving the entire process will be completed and the person concerned who is transferred, he will join. And the process will start when? Since 15th April. 15th April. So the period as your lordship was asking for is from 15th April to 10th June. 10th June.
That is for rationalization.
Beyond that, it becomes beyond transfer season transfer, and for that
director can.
Yes, the next higher authority since the transferring authority is district education officer, the next higher authority is
The director.
Director Elementary Education. That is why. So here all these orders, before your lordship,
beyond that.
all
Beyond that.
decisions having not been made by the director, rather by the
District education
officers who are incompetent to pass such orders at this point of time.
And your lordship may kindly see, yes, without jurisdiction. And your lordship may kindly see, yes.
This transfer season is prescribed keeping in view the interest of potential transferee.
Yes.
Yes.
Because he has to have his children admitted
Several
to
other
some-
languages.
Yes.
And he may have the children of spouse also.
Yes.
Quite possible.
Yes.
So, in order to facilitate all these things going smoothly, they have fixed this period. And there may be extreme cases where a director will transfer.
Yes.
They are more in the nature of exception.
Yes. And my lord, one judgment of the Honorable Apex Court.
The transfer period is between 15th of April to 10th of April. Such a period is very wisely divided to avoid the difficulty which the transferee would be put to if he is made to leave the family without making adequate arrangement. Whether all they will be getting the quarters?
No quarters. Here there is no such facility. Not a single one.
No quarters at all?
No quarters at all.
Some teachers, some teachers of the government schools there. No.
Elementary
Elementary high school.
I'm asking one more thing to you. When you transfer X to particular place, how he should secure the rented premises? Whether these premises are available in every village?
My lord, it is not so far distance from their schools. That also they have been taken care of.
How many
It is within 20-25 kilometers.
In the district are more than 300.
Yes.
No, it is not 300 kilometers.
Yes,
It is not that.
Other day.
It is
Yes.
No, they are saying so. No. Previous school
there is no quarters provided. Even
quarters are not provided.
Elementary cadre teacher. Here the emphasis is on elementary cadre teacher.
There is no single quarter.
People are concerned with. My learned senior says for secondary cadre, some of the teachers
are
quarters to be accommodated.
Government schools.
Besides our point,
Those schools who are having drawing disbursing, they are having some.
have no quarter.
Views have what to speak of teachers.
It is admitted at the bar that for the elementary teachers,
Yes.
there are no government quarters facility.
Yes.
And therefore, they have to make their own arrangement.
They are getting house rent allowance.
They have to make their own arrangement of securing the accommodation. Although house rent allowance is admissible.
Yes, they are admissible.
Suppose if you transfer them in the all of a sudden in the middle, how can they get houses? So with least 15th of May to 10th of May, June, I can understand. Almost about 2 months, 1 month to 25 days.
Yes.
Somehow they will go in the summer heat, they will contact people and they will secure the houses, I can understand. But all of a sudden, if you transfer them and ask them to report on the first day of opening of the school, where he has to sleep in the school itself. Many aspects are there.
That the authorities will think over it. They have to take a decision.
But there is no accommodation.
There is one thing. This system has been working since decades.
Yes. Yes.
Therefore,
Yes.
they on the workability, they say it is working.
have
Like
also
that. Therefore, we need not make separate provisions.
My lord, with regard to the submission made by my learned senior regarding that provision of appeal, your lordship will find that it's a case of seizure to seizure. Why I say so? That
Caesar to Caesar's wife.
here itself, your lordship may kindly mark.
Appeal itself is to Caesar.
My lord, your lordship may kindly mark one point from the very transfer guideline dated 14.5. Your lord, clause 3, where it lays down the intra-district transfer procedures, they are sub-clause italics 3, again sub-italics 3, sub-italics clause 5 may kindly be seen.
Whom it designate? Director.
No, the director will ultimately, or the director elementary himself will do, will forward, will just a minute, my lord, I am getting it for your lordship's appraisal. Your lordship may kindly come to.
Not 10th of June, it is 15th of June.
15th of June.
Your lordship may kindly page 32, subclause 5.
The proposals of the honorable MPs, MLAs.
I am referring to that circular of the executive instruction of 14.5, 2025, where that under clause procedure for intra-district transfer, which is available at subclause 3. You also got it?
Clause 3.
Yes, madam. Procedure for intra-district transfers. That is the marginal heading. And thereafter, subheadings 1, 2, 3, 5, 3, 4, 5, likewise up to 8. Your lordship kindly marks 5.
Why these orders have no internal pages? You have wiped internal pages.
No.
Then why they don't have pages at all?
They don't have pages.
So, yeah, my lord, everything is being done as your lordship. It has been pointed out to your lordships. Everything is done on computer-based system, and computer-based system at the top, your lordship, your lordship kindly mark. NIC at the district level through computer, all transfers will be carried out solely on the basis of data available in UDISC and teachers profile database duly validated by the concerned DEO.
No, what you want to say?
Let me discuss the education officer, bro. Director.
Brother, what is the point you want to make out?
My lord, here, my lord, since the very approval of DLTC is ultimately being uploaded and getting the nod of the director or the knowledge of the director, by again making an appeal to the director, it carries no meaning because.
No, that is informed to him that we have transferred like this. He will not treat it as appeal. Those who are aggrieved, they can make appeal. Is a government's contention. And they say, suppose if the transfer committee is unduly influenced by the suggestion of MLA, MP, because it violates the norms. Then they can file a
very clause 5 which provides appeal and review. The very clause 5 which prescribes for appeal and review, the last line thereof says the directors shall also have powers to review and modify inter-district transfers. So ultimately, the committee and all these justifications, whatever under which the decision has been made by a multi-member committee, that will be directed. That will be interpreted.
Your lordship may kindly see. Perhaps my
basis of the recommendation made by
the Satan.
The MPMLA.
No, Satan. Your lordship may kindly see the 13/5/2025 order.
What you want to see?
Para 5. Your lordship may kindly see. Take para 5.
Clause 5.
Yes.
Clause 5. The proposals of the honorable MPs, MLAs.
Page number?
Page number 23 of my brief.
13/5 circular.
13/5/2025 circular.
Letter.
Yes. The proposals of the honorable MPs, MLAs are to be submitted to the concerned district collector
and will be disposed of by the district level transfer committee. That is what where the parliamentary constituency covers more than one district. The proposals will be submitted to the nodal collector under intimation to the other collectors within the jurisdiction of that PC for disposal by respective DLTCs, district level transfer committee. In case of Honorable MP Rajya Sabha, the list may be submitted to the Director Secondary Education under intimation to the Director Elementary Education. The DSC will forward the list to the respective collectors under intimation to the Director Elementary Education for disposal of the same by the DLTCs. If the Director Elementary Education, he after getting the recommendation of the MLA MP, he sends it to the district level transfer.
It is not MLA MP, only Rajya Sabha.
No. In case of Rajya Sabha,
there is a full stop.
No, the list may be submitted.
In case of Honorable MP Rajya Sabha, the list may be submitted to the Director Secondary Education
under intimation to the Director Elementary Education.
Yes. Stop.
Then stop. Then it is stopped. The DSC will forward the list to the respective collectors.
Yes.
Under intimation to the Director Elementary Education for disposal of the same by the district level transfer committee.
Yes.
No, it should be written conjunctively. Your Lordship,
this is not in all cases.
Previous line. The proposals of the Honorable MPs, MLAs are to be submitted to the concerned district collector and will be disposed of by the DLTC where the parliamentary constituency covers more than one district. The proposals will be submitted to the nodal collector under intimation to the other collectors within the jurisdiction of that PC for disposal by the respective DLTC. Yes.
I am also saying that.
No. Here, they will go through the Director Elementary Education. And if
I am saying that.
And he is the appellate authority, what he will do?
They are to abide. Where those people will go? Well, they are only abide by the regulations made in the notification. 14.5.
Well, I have brought a judgment.
They cannot go beyond that.
A single one regarding this recommendation of
yes.
No. They are to abide.
There is no subjective satisfaction. You Lordship, kindly
the criteria laid down in 14.5 are to be carried out. In addition to that, my lord, there is a guideline. Condition. Yes, there is a condition.
That guideline is saying that in teachers will not be transferred to urban areas. Where is that contemplated in 14.5?
13.5.
Then where those people will go?
Yes.
Suppose I am recommended
by Rajya
Sabha MP. Then I cannot file an appeal. That provision is not there.
No. He is not deciding.
He
is not deciding your case. No. He will only forward the matter to the appeal. District level transfer committee. He is not sitting on appeal. That he will hear you. He only
take recommendation only to the committee.
Yes. He will not take the decision.
Well, here your Lordship may kindly see. Well, as recommendation of the MLA and MPs are concerned, there is no satisfaction arrived by the DLTC's committee. I am relying upon a decision. Your Lordship may kindly see. It has been exclusively dealt with. Well, this is a Himachal Pradesh decision. Para 22. I have flag marked it. Para 22 of that judgment may kindly be seen.
Sir, citation tagon?
Citation ta hoji it is CWP 2621 of 2020.
This is also two judges.
Two judges. Para 22. My lord got it. It again.
So now I have got two judges' judgment of two high courts.
Yes. But your lordship may kindly see para 22.
Yes, I read that.
Yet again, the issue of transfer at the instance of elected representatives came for consideration before the learned division bench of this court in such and such, wherein it was observed that it is the head of administrative department who alone has jurisdiction to transfer the employee, that too on the basis of subjective satisfaction. The authority making the transfer is to be guided by transfer policy in vogue. Then your lordship may kindly see para 23. It shall be opposite to refer para 23 of the judgment, which reads as under. Then para 24. Similar issue thereafter came up between the learned division bench of the court in Rajkumar versus State of HP, and after placing reliance on the judgment, Sanjay Kumar case Supra, this court observed as under. My lord, thereafter your lordship may kindly come to para 26. As already observed above, the chief minister and minister elected representatives may recommend the transfer of an employee has already been held by this court in Sanjay Kumar and Amir Chand's case Supra. However, the transfer orders are ultimately to be issued by the administrative head after independent application of mind, that too after subjective satisfaction without being influenced by the recommendations so made by the elected representatives. In the instant case, there was no independent decision taken by the administrative head. Rather, there was no scope left for the said purpose, and therefore the decision has been rendered vulnerable as being influenced by the proposal and recommendations made by the local MLA. Then other things are there. Ultimately, that was quashed. And another judgment.
Reference there to banks upon the Himachal Pradesh High Court. Take Raj versus the state of Himachal Pradesh. CWP 261 of 2020, decided on 17 in 2020. First off, he particularly draws attention of the court to paragraphs 22, 23, and 24. And
26 also.
26 also.
Yes. 26 and 27.
So 28, 22,
22, 30, up to 30.
Thirty-one also.
31 also. Up to last paragraph. Good.
Can I submit another judgment, my lord?
Yes, sir.
ମୁଁ ଖାଲି ରେଫର କରିଦଉଛି ଆପଣ ସାରି ଦିଅନ୍ତୁ ଆହୁରି ଅଛି My lord, there is 2007 volume 8 SCC 150 I'm referring to. And another
referring to, I think it refers to the other employees other than teachers.
Yes. Yes, it is also transfer on the recommendation of MLA. It was
Correct,
there.
because they work as executive engineers.
My lord, it was
all these people.
My lord, another judgment is Union of India versus.
Well, you which paragraph? You read that.
I'm referring to it while deciding.
Citation wherein it has been held that even the ministers cannot transfer. And not only the chief minister has the authority to transfer.
Scope of
We should do the citation.
Yes.
Where is the citation?
The citations I have just downloaded from the Supreme Court website. I will give.
Which paragraph?
First, page 11, madam. Page 11, 5.10.
Yes, but
We are also of the opinion that the postings of all group officers must be done by the head of the department in a state, and the same tenure route shall be given a statutory lacking. We are advised that some witnesses taken in case of Group A officers / officers of all India services, and no minister of state should have any powers to order a transfer or approve a proposal for transfer of any official, either of any state service or of all India service. We agree with this view, as in your opinion, going to reasons of political expediency or even
Paragraph? Which para you are reading?
the page 11, paragraph 5.10. 5.10. Page 11.
No, this is not, this is the Bhutta committee recommendation.
Yes. My almost the ratio is applicable that even the minister doesn't have.
It's a committee recommendation you are reading.
Yes.
But where is the decision of the apex court?
Decision is the lordship kind of task page para 27. 27. 27 at page 41. 41.
What is that CSB?
Civil Service Board, Civil Service Board. That is, we find it however difficult to give a positive direction to constitute an independent CSB at the center and state level without executive control, which Hota committee has recommended to be statutory in nature, that too comprising of persons from outside the government. Petitions placed considerable reliance on the judgment of the court in Prakash Singh and others versus Union of India, and urge that the similar decisions be given to insulate to at least some extent the civil servants from political plus executive interference. Retired persons, however eminent they may be, shall guide the transfers and postings, disciplinary actions, suspension, reinstatement of civil servants unless supported by law enacted by the Parliament of State Legislature. 28. CSB consisting of high-ranking in service matters who are experts in their service fields with the cabinet seat of the center and chief secretary at the state level. Alternatively, till the Parliament ends a law to guide and advise the state government on service rights, especially on transfers, postings, and disciplinary action gets through. Their views also could be overruled by the political equity. But by recording regimes which could ensure good governance, transparency, and accountability, government of functions, Parliament can also, under Article 9 of the Constitution, enact a Civil Service Act setting up a CSB which can guide and advise the political executive transfer and questions. CSB consisting of experts in various fields like administration, management, science, technology could bring in more professionalism, expertise, efficiency in government. We therefore direct the center, state governments, and union territories to constitute such boards with a high-ranking service officers who are specialists in their respective fields within a period of 3 months, if not already constituted, till the Parliament brings in a proper legislation in setting up CSB. Then, my lords, 28, 29, 33, to paragraph 33 at page 40. 33, 44.
No, where is the MLA MP recommendation?
Those paragraph 510 at page 11, it was clearly mentioned that again page 11, man. We are also the opinion. 5.1. We are also the opinion that postings of all groups and southern there after 3 or 4 lines. It is the only the chief minister's orders for transfer should be taken in case of Group A officers of all India services, and no minister of a state have any powers to order a transfer or approve a proposal for transfer of any official, either of any state service or of the all India service. We are therefore, we agree with the view, as in your opinion, owing to reasons of political expediency or even due to unwholesome reasons, ministers in states are not able to make proper use of the power vested in them for transfer of their departmental officers. So, if the ministers are not allowed to make transfer, so what is the question of MLA and MPs exercising their power? They are only in respect of policy making bodies.
No, that is for civil service.
Yes.
Not for teachers.
And
what judgment is for civil service. IAS, IPS, IFS, all those categories. And the state service cadre, not teachers. Because para 3, it reads that way. Because they have to take decision independently, being head of the department. Therefore, they should not be made to suffer the pressure, pull and pressure of political bosses. Therefore, Supreme Court said, constitute a board. Therefore, this judgment does not come to your aid at all.
My learned senior officer, he has cited the decision in regard to that Prokash's case. That is somebody reported in 2006.
Prakash Singh first time provided for establishment of the board to ensure that there is no arbitrary transfer of IAS, IPS, IFS officials. But this judgment which you are citing is about the executives.
Only ratio. I am citing only for ratio of the judgment.
What is the ratio?
Yes. As regards the provision to appeal, my lord, there is willful corporation decision is there. When a particular order is passed without jurisdiction, then my lordship has every right to the power to exercise the power under Article 226 of the Constitution.
One more judgment.
Public quotation in PSR Subramanian versus OI. What is the citation?
Citation.
New states
In some states the fixtures cannot influence the transfer. And therefore, the MLAs and MPs also cannot.
But I am citing one more judgment. That is 2003-11 Supreme Court cases, page 740. Sarvesh Kumar Avasti versus UP Jal Nigam and others. It is also at the instance of MLAs and MPs.
Yes.
Paragraph 2 and 3.
What it says?
Paragraph 3. In our view, transfer of officers is required to be effected on the basis of set of norms or guidelines. The power of transferring an officer cannot be wielded arbitrarily, mollified, or an exercise against efficient and independent officer, or at the instance of politicians whose work is not done by the officer concerned. For better administration, the officers concerned must have freedom from fear of being harassed by repeated transfers or transfers ordered at the instance of someone who has nothing to do with the business of administration.
Paragraph. What work the MLA will have with the teachers? It is for executive engineers where contracts are.
Yes. Yes. Yes.
In that context, this judgment is given.
This judgment is given.
What work the teacher, the MLA will have with the teacher? Nothing that give good tuition to my students.
But the decision, and another judgment, that is Madhya Pradesh High Court.
Relevant judgment.
Yes.
Only relevant judgment.
Yes. Your Lordship may kindly see this is in the writ appeal.
In Madhya
Pradesh High Court. Page 5, internal page 5 of that judgment. Here, my lord, your lordship may kindly see. This is also on the.
What is the proposition?
Proposition is, my lord, proposition in page 4. It is needless to say that an elected representative can always recommend a transfer of an employee. However, such a recommendation has to be for genuine and cogent reasons. It cannot be justified by usurping the authority of the concerned administrative department. In the instant case, the concerned administrative department has declined to transfer the petitioner. The same has also been endorsed by the principal secretary of the department. Notwithstanding the same, the concerned minister has made a recommendation contrary to the opinion of the department. The said file was placed for approval before the Honorable Chief Minister, who was therefore compelled to approve the same. Such interference in matters of transfer, in our considered view, is highly inappropriate even though there can always be a recommendation, it cannot be forced upon the concerned authorities to effect the orders of transfer. The transfer of the petitioner, therefore, is not on any administrative ground or in public interest, but only due to insistence made by the concerned minister in view of the facts and circumstances involved. And as disclosed by the original records, the transfer orders becomes unsustainable. No transfer order can be sustained if it is made purely on the ground of a recommendation made by a minister. Therefore, we are of the view that the impugned order becomes unsustainable in law.
Thanks upon a Madhya Pradesh High Court judgment.
Division bench.
In Shyam Kumar Singh versus State of MP. Writ appeal number 400 of 2022. Decided on 27 April 2022. He draws attention of the court to the observations at para 4 and 5, page 4 and pages 4 and 5. But that judgment observes that it is needless to say that an elected representative can always recommend
the transfer of money. Yes. Yes. However, such recommendation has to be for genuine and
without reason.
Yes.
Including MLA or MP in the as the recommending persons.
Yes.
How this supports their view.
No, my lord. Subsequently, your lordship may kindly see there is no subjective satisfaction arrived at by the district level transfer committee or the authority who has issued the order of transfer. Where is the subjective satisfaction? Simply they have acted upon the recommendation made by the MLA.
Not all, subject to condition.
Where is
Conditions are there.
subjective satisfaction?
Some conditions are there in 13.5. It is there.
No, nothing
You
is
have
there.
already placed, yes.
Nothing is spelled out.
13.5/2025 letter.
Is that on the recommendation of the MLA?
Where the recommendations of the MLAs, how they have written, why this teacher should be posted as.
That recommendation I do not have, my lord. But simultaneously, one judgment, it is 2007, volume 8, Supreme Court cases 150 at paragraph 8. My lord, learned counsel, it is a case of recommendation of, even though it is not a case of teachers.
That is the problem.
My lord.
Teachers stand on a different footing.
Yes.
They build the nation.
Their lordship said, my lord, learned counsel for the appellant submitted that the impugned transfer order of the appellant from the Muzaffarnagar to Muavana, district Meerut, was made at the instance of MLA. On the other hand, it has been stated that in the counter affidavit filed on behalf of respondent number 1 and 2 that the appellant has been transferred due to complaints against him. In our opinion, even if allegations of the appellant is correct, that he was transferred on the recommendation of an MLA, that by itself would not vitiate the transfer order. After all, it is the duty of the representatives of the people in the legislature to express the grievances of the people, and if there is any complaint against the official of the state government, is certainly within its jurisdiction to transfer such employee. There can be no hard and fast rule that every transfer at the instance of MP MLA would be vitiated. It all depends on the facts and circumstances of the cases of the individual case. In the present case, we do not see any infirmity.
It's a case of read.
My lord.
Everyone should be aired in the legislature house.
Yes.
See that sentence which you have read now. You cannot send it. You can always say on the floor of the house, this concerned school teacher is not teaching well at all. Children are being spoiled. He smokes, he drinks, he misbehaves. Children may draw wrong lessons. Therefore, you transfer him elsewhere, remove him, as the case may. That he should say on the floor of the house. You have read that?
Yes.
The word legislature is there.
Yes. Representatives of the people.
Para 7 is important also. That he has not read. I brought it.
Then it will be punitive transfer. Then it will be punitive transfer. In that case,
Yes,
Somesh
got it.
Tiwari comes to our.
He has got the judgment to use against me.
Somesh Tiwari.
I have given it.
The task is saying that you have snatched that judgment.
No, I have given it to him. I have given it to him.
You give it to him.
I have given it to him.
That supports the government's case.
Not that. Typically, just I have given two judgments. I have given. You just go through this. I have given it. Can listen.
Para 7 supports him, Para 8 supports me.
Para 7 not supports anybody. This is a case of executive engineer, not a case of teacher. However, Para 7 says that he must have the power. First of all, judicial review.
First line of?
Last line of Para 7.
Para 7 is small paragraph. Kindly see, madam. Judicial review.
The
scope of judicial review transfer under Article 226 of the Constitution of India has been settled by the Supreme Court, so and so, so and so, so and so.
Yeah.
Now, my lord.
The law laid down
The laid down in the aforesaid decision that an order of transfer is a part of the service condition of an employee which should not be interfered with the ordinary by court of law in excess of discretion under Article 226 unless the court finds that either the order is modified or that service rule prohibits such transfer or that the authority who issued the order were not competent to pass such an order. Here is one of this is
incompetent.
The service it will take that guideline to be the rules for the purpose of this case. 14.5 circular never provides for a power to that MLA to recommend.
No, I am also not saying that.
13.5 was not included in 14.
I am not also saying that. I am also not saying that. Yes.
Rather, the transfer order says
there is no
request of the
there is no violation of notification dated 14/5/2025.
Last but one paragraph. Here, these transfer.
Your Lordship,
For arguing amongst yourselves, I am an onlooker. Yeah.
Your Lordship,
it is
Within the citations, TSR Subramanian, that is AR 2014 SC 263. I will
Writing on that statement, right, sir?
Yes, AR 2014 SC 263.
Lastly, my lord, I will conclude by saying that we are not violating the notification dated 14/5/2025 by issuing this letter 13/5/2025 because of the fact that they will also recommend the names of the teachers to the DLC. And DLC, after all, according to notification, they will take a decision.
One thing, Your Lordship may kindly see the transfer order itself under Annexure 2. Nothing has been mentioned excepting recommendation of the MLA.
Not necessary.
Page 19. Second paragraph.
What it says?
These transfers have been made on the basis of recommendations so received from different honorable MPs and MLAs of Mayurbhanj district. Yes, that is the only reason.
Yes.
Just read in every.
I am reading out
in every case
in the serial.
Pursuant to the
letter dated 13/5/25.
Yes,
14/5/25, the School and Mass Education Department, Odisha, Bhubaneswar, and as for the approval of the district level transfer committee meeting held on 15/6/25, the following elementary teachers are hereby transferred on administrative ground on the recommendation of the honorable MPs and MLAs during the current transfer session 2025 and posted to act as such in their own scale of pay in the school mentioned.
All orders say the same thing.
Same thing.
In my case, it reads like this. Pursuant to notification
dated 13/5/2025. That is there.
That letter of Additional Secretary to Government for SME Department and on consideration of the recommendation of the honorable MPs and honorable MLAs of the Puri district for transfer of teachers. This has been done.
Yes.
A list of teachers.
No more regions. List of teachers.
In my case, my lord, transfer order was passed on the basis of the recommendation of MP and MLA. I filed an appeal pursuant to the direction of this honorable court.
That was rejected.
they said since it was done in pursuant to direction of the recommendation of NPMLA, appeals can't be taken. As bylaw said, once recommendation has been made, they can then.
Advocates has draw attention of the court to the text of impugn transfer order, which specifically say that the said transfers have been made on the recommendation of MPs, MLAs. First off. In one case, that is WP number
22526 and three other sources. Four matters there. Like this.
In four cases.
I'll give number.
In few other cases, even the appeals filed with the teachers against the transfer orders have been rejected on the sole ground that the same orders were made on the recommendation of MPs for MPs.
I'm reading.
You are reading, no? Anything new?
No. In my case, my lord, only this letter number 13/5/2025 has been made, and it has been written like this. In pursuance to the letter number 13/5/2025, read with the notification of 14/5/2005 school organization and due approval by the district level transfer committee. The following elementary cadres are hereby transferred posted. That means 13/5 means
It refers to MLA.
In every transfer order that has been mentioned, 13/5.
Because
Not the other way referred to. The letter dated 13/5/2025, which provides for recommendation by MPs and MLAs.
because they have to recommend to the district level transfer committee, that's why they have referred.
Well, I have a small prayer.
Yeah.
That is WPC number 23841 of 2025, Lakshmi Singh versus State of Odisha. Here MLA and MP recommendation is there. He has only 6 months to go for his retirement.
No, that is
go for a retirement, and as per the guidelines,
that is
Roman 10, the teacher / headmaster having less than 2 years of service for superannuation may not be transferred.
no, that is bad.
That
yes.
allow that matter.
Yes.
In WP number
23841 of 2025.
Petitioner is laying a challenge to the transfer order dated
16/8/2025.
16/8/2025. At annexure,
That is annexure 2.
at annexure 2, whereby he has been posted to
He has been posted to Government Upper Primary School, Bauso, Contia.
First, the net counsel from the petitioner submits that
She will retire on 30.
E.
Here,
that it is
C.
a violation of the norms promulgated by the government by its notification dated 14/5/2025, which restricts the transfer of an employee who is about to retire on attaining the age of superannuation.
Having less than 2 years of service.
First, he adds that ordinarily, an employee who is going to debit the office within less than 2 years is not liable to be transferred. Save in exceptional circumstances. Find that there are no exceptional circumstances. Next paragraph. The AGA, Mr. G, makes submission in justification of the impugned order, contending that the transfer guidelines are only guiding lines and their violation would not give a coherent cause of action to ventilate the grievance before the rate courts. First one, he adds that all employees are liable to be transferred and at times divorce the guidelines to first one. If there is any grievance, petitioner should work out the same in the departmental appeals. Next one, having heard the learned counsel for the parties and having perused the petition paper, this court is inclined to grant indulgence in the matter in as much as the important factor that the petitioner is going to lay down the office within about 6 months or so.
34, 2026.
That is 34,
2026.
not 6 months. That is more than
8 months.
about 8 months.
About 8 months.
Has not been.
Yes, November.
April, no?
April
Less than 6 months.
Less than 6 months. Mathematics.
No special reason or other reasons are assigned as to justify transfer of the land. First one. The transfer guideline, which is that page.
That is
the transfer guideline.
page 30 of that brief. Roman 10.
No, you say that transfer guideline number, which is
Transfer Annexure 4. 14.5 2025.
5/2025. At the 45, relevant part of the transfer guidelines, they take 14/5/2025.
Roman 10.
As a, which is that?
Roman 10.
Page 31.
Page 30. Roman 10.
X.
X. The teacher oblique headmaster having less than
just a teacher
oblique headmaster having less than 2 years of service
2 years of service
for superannuation may not be transferred.
For superannuation may not be transferred. First off, although the guideline employs the word may, the same has to be construed as shall. The text and context of the guidelines, which are issued for securing for avoiding hardship to the retiring employees. First, an argument to the contrary would cause heartburn to the employees who are in the who are going to demit the office before long. In the above circumstances, it is petition succeed. The writ of certiorari should include order. First of all. Are you still continuing?
Yes. By virtue of the interim order, I am continuing.
Petitioner shall be continued in the same place wherein he has been presently working by virtue of interim order dated
26/8/2025.
26/8/2025. So then it's your the submission of Mr. Chief that Melody, you do like this, how I should give. Even in high school, even in primary school, I used to behave better than really. I never misbehaved with the school. I never misbehaved with the judges. I never disturbed the court proceedings. Suppose if I get down now, how are you going to get justice? And many will be seeing the video. Let your children, your aunts, your mothers, parents, let them see what the judge is telling to you people. Yeah. In as much as appeal of the kind is only departmental and that even otherwise the alternate remedy is not involved to the exercise of the jurisdiction. Penal that. Yes, which are those cases where this hard result.
This is the 13/5/25 order is under challenge. That was continued. That letter of that government. Along with the order. Yes, joint secretary letter. That is the impugnment. Along with the order of transfer. Along with the order of transfer. In all cases.
One of the matter.
Take care of the transfer order. Kindly keep quiet. The transfer order is in challenge on the ground that they are violative of the government guidelines dated 14/5/2025. First one. In a few matters, challenge is also laid to the letter dated 13/5/2025, which provides for recommendation of MPs, MLAs for transfer of teachers.
My lord, in the
This is the matter appeal was rejected.
Appeal was rejected.
my lord, in this
Now, come to the cases of eviction. Tomorrow
my lord, can I
eviction.
mention in this case
Appeal is pending. They are not allowed me to perform my duty for which my lord are directed.
I cannot do 15.
my lord, can I
Add to that common.
With your lordship's permission, my lord. With your lordship.
One writ petition of the same 47 item. I have earlier mentioned before lordship that the petitioner is present.
30666 of 23.
Transfer.
Yes.
Transfer.
Secondary teacher.
No, is it secondary teachers stand on a different footing? No.
No.
It is
Same.
serial number?
Serial number 3066
of 25.
Serial number
47.
47.
Same
Is
47.
it a schematic?
in this section
High school teacher. Regular teacher.
Only the prayer is, my lord, he is interested with it that entry model is there, my lord. I am continuing in my place. And now the open number 4 is appeared and he is saying that.
Let all these matters reach, my lord. We have not seen those records.
No, that is
What is a similar matter?
They said that.
That is the list.
That is
MLA and MP.
Yes,
ma'am.
that list 47.
It is whether MLA MP is mentioned in the X
Yes.
order is
That's
mentioned.
also put in.
my lord, in this 47 there is a no item 22004 they transfer on administration ground.
On
Administration ground.
administrative ground. No MLA.
No MLA ground.
Remove them. That WP number.
And entry mode is
Not there. What was number?
22004.
WP 0004. 22004.
004.
Of 25.
25.
Subject detail.
With your
Entry
lordship.
mode content.
With your lordship's permission, my lord. With your lordship's permission.
2000, there are two notifications, one elementary and secondary.
But for both the notifications, this letter is applicable.
No,
MLA MP letter is applicable to both the notifications.
that is addressed to whom? Director? Elementary. Elementary.
And that is secondary.
They don't have both.
Both is applicable.
But two notifications are there.
Separate for
With the lordship's kind permission, my lord, item number 47, this is the MPML is transfer, and 31556, the page is what is number 5, it needs to be corrected address, longly time.
no issue.
I'll carry it. Already filed.
You filed it.
Already filed.
But the elementary so to get different
31556.
Of the request of
31556.
WP number 31556 of
25.
25 on the request of for the petitioner.
OP number 5.
OP number 5
Only address is
properly described by rectification.
of that.
Item 7, the petitioner has already joined this to
Is it MLMP? Then he will go back, but only after the academic year. Wherever the candidates have already joined, have reported for duty at the transferred place, they shall be sent back to the original place after the end of academic year. This will be general order because now we cannot disrupt the teaching and other things. In the event, if I allow the petition,
Yes.
in the event I dismiss, then question will not arise.
Highly obliged.
Special.
So notice item 1.
All which are those?
Yes, I have one.
They can't be. They cannot be done now.
Item number 40 also we have fixed at 2 o'clock because of this matter it would not be taken up. Can you also, Mr. Lenka is there. Then you also can you take up the next week on Monday or Tuesday?
Which is that?
Item 30.
That is the diploma course.
That diploma.
18 months and the 2 years diploma.
That one, yes. You also have specifically fixed at 2 o'clock.
Four zero.
Yes, 40. Yes, Mr. Link has some problem to day after tomorrow. That's okay. Also keep it to next week on Monday or Tuesday. Any date convenient to us.
This I have read the file actually.
Yes, yes, sir.
Can we have it on Wednesday?
Yes, sir. Wednesday.
We'll try.
This one is day.
Yeah.
But I have one letter in result.
January.
No, that Wednesday also keep it.
No,
I'll see.
Wednesday, your lordship had specifically urgent one Mahanadi coalfield case. That is a
Thursday will.
Thursday.
Thursday.
Yes. Thursday.
Same if you also your lordship had fixed that
The rest of the things.
2 p.m. your lordship had fixed item.
Number 53.
Which are those other matters? Take new list. Special notice item. Other matters are 3 on 4. Yes.
Item 1. The page 11 is the impugn notice. Page 11, annexure 2 is the impugn notice. The notice of eviction was issued on 18/11/2025. Only 7 days time given to the petitioner to remove the encroachment. Yes, madam. I am only put a cabin and a small, running a small shop, maintaining my livelihood. I am not in the way to vacate the land in question. Only I pray your lordship kindly give me 2 months time. In that I will vacate the land. I will make an alternate arrangement. The notice was issued on 18/11. After 7 days, they are fixed to remove the encroachment.
We'll issue notice and I'll give you stay for 1 week. Next date, I'm getting it posted. So that I dispose of on your undertaking.
Yes.
Mr. Ray, he says within 2 months he will vacate the premises only.
Lordship, it is after by dismissal of the revision case.
Correct.
Initial encroachment case was there in 2023. Thereafter, file appeal. Appeal also dismissed.
No, it says, I will quit the very quitting itself. It's a government.
Roadside matter. There is no developmental work of the government.
1 month will give you, if you are agreeable, well and good, because it's your roadside, you have put up the construction.
Not only wooden cabin, man. Only wooden cabin, small cabin.
That's all right. Yes. 1 month will give you, if you are agreeable, well and good. Otherwise, I will dismiss the petition. It is not your property.
No, it's not my property.
If you agree, 1 month I will give you. Otherwise, I am dismissing the petition. Take off. Petitioner.
Only I pray.
Yeah.
6 weeks time. 6 weeks time.
No. File 6 weeks. You will.
Yes.
If you do not do, throw all those things on and arrest him also. Okay. I will say that consent order within 6 weeks is.
Yes.
Both the sides having argued the matter for some time. Now graciously we agree with the suggestion of the. We'll say that with the suggestion of this court. With the suggestion of this court, that the petitioner should remove all encroachments and quit the place in question peaceably without seeking any extension, within a period of 6 weeks, reckoned from this thing. First off, failing which it is open to the OPs to throw him out with the police force. First, ordered accordingly and writ petition is disposed of.
Till that season, till that may not be no question.
Yes, with the above observations, the petition is disposed of. 6 weeks. Yes.
Within 6 weeks, he may not be.
From today.
From today, he will not be evicted. That line.
No, he will not be evicted.
That line may be.
For a period of 6 weeks, the petitioner shall not be referred by the OPs.
Only one prayer, madam.
Yes.
Can it be uploaded today because tomorrow is the date of eviction?
No, Mr. Ray, I instruct your officials. Perhaps I may, because we have disposed of many matters. That's the I will try to post also. Wait. Yes, next.
Item 2.
Item 2.
I have given an order, my lord. The coordinate bench has passed this order.
Saying?
OPLA Act pursuant to notice, my lord, I have approached this honorable court. I'll file an appeal before the sub-collector, opposite party number 4.
The subject matter of this appeal, this petition, is substantially similar to the one in WP 27985 of 2025 between Sabita Panda versus State of Odisha, disposed of by a coordinate bench of this court, by order dated 26/9/2025, wherein paragraphs 5 and 6, 4, 5, and 6 read as under. First off. Next paragraph. In the above circumstances, the relief as has been granted by the coordinate judge is extended to the petitioner mutatis.
A copy in course of a date.
Yes.
Tomorrow is the date of eviction.
Item 3, same thing.
Item 3 to 7, my lord. With a similar matter, your lordship will this coordinate badge and pass the order, my lord.
Mr. You have to serve a copy on the other side.
My lord.
Yeah.
My lord, I have already written, your lordship pardon me because I have marks on me. 4, 5, 6.
Same order.
Same order, my lord.
Same order.
My lord, in urgent certificate copy.
3, 4, 5, 6.
7. 3, 4, 5, 6, 7, my lord. 5 matters, my lord.
7.
My lord, in urgent certificate copy in course of date, my lord. Because tomorrow is the
Yeah. Do them today. All right. 8 ones.
Item 8.
Item number 8. Item number 8. What is that matter? Give me, because of urgency they have posted.
It is also well sent to the
web copy. This web copy. Just to show that.
Pradeep Kumar Singh.
Any IA is fighting this?
I is there, madam. Lordship will pass same order, madam. It is also in same footing, madam.
Same order.
Same order.
Which order?
That in the previous order.
Series matter.
Lordship.
Same order.
Yes, madam.
Are you sure?
Yes, madam. Call form has been issued, madam. That is the eviction notice.
That also same order, but only dates and other things.
Dates and the here is the Tahsildar is the opposite part of 4, madam.
Order dated 31/10/2025. That you have to add there. Yes. Then
Item 53, your lordship, it was kept. Item 53, your lordship, it was kept for today for 2 p.m. Looking at the urgent. Yes, your lordship. That's why I was saying, can it come tomorrow at 2 p.m., your lordship?
50, 50.
53.
Instead of tomorrow, day after it.
Yeah, that's true.
Your lordship has fixed the other matter.
So let it come tomorrow, your lordship.
Tomorrow I have heard, can it be on Friday from possible?
Friday. All right, we'll have it on Friday.
Your lordship, not Friday, the bench may not happen, the division bench happens, another benches happen. Thursday, let it come Thursday, your lordship. Let it come Thursday.
Thursday, we have, it appears we have posted some.
Your lordship posted. So let's it's a clear day, your lordship. Monday.
Coming Monday.
Coming Monday.
Okay.
Coming 2 p.m.
Your lordship, item 48, your lordship.
53. I'm appearing for the Staff Selection Commission. I have filed my application for objection to their application for amendment. And also a date that I have filed that can be kept on record. So that is in the list.
We just need to post all of this.
Your Lordship, item 48, Your Lordship. Your Lordship, item 48 was put for today for disposal, Your Lordship. The petitioner is retiring this Saturday, Your Lordship.
This Saturday. Let him retire. What happens? We will get everything. I know.
Your Lordship, the petitioner has been demoted from the post of principal to reader. Your Lordship.
Get everything, na?
Your Lordship, the salary also has been stopped. It may come tomorrow.
December, second week of December.
Item 49, Your Lordship. Item 49 is the student career consulting method, Your Lordship. The semester has been withheld by the authority, Your Lordship. I have filed an IA for Your Lordship. So I pray Your Lordship can taken on the heading of the press and himself. It's a very small matter. It will be disposed of.
Post it tomorrow.
Item 49.
Item 25.
What is the urgency, brother? Real urgency, if you tell me, I can understand. Unnecessarily just
Now the
pressurize the body.
Bhubaneswar municipality is going to form a slumdole association by violating rule 8 of the.
Post it in the second week of January 2020.
Item 41, Lord, interim further proceeding has been stayed. Is a proceeding of 2018. Lordship, item 41 that was passed over. Lordship, can you take out tomorrow, day after, any day, Your Lordship?
Any day in the second week of January 2020.
No, Lordship. Further proceeding has been stayed, Lordship.